right. That's a statement that you are clarifying now. Thanks.
But where you had once indicated that in all the transactions, on all these transactions, you were dealing with Mpofu and Mpofu only, except one transaction when you communicated with accused number 2, Michael, right?
Yes, in terms of communication write-up, but they were visiting my office.
But now
the two of them.
But now you are telling the court that you received communication from one gift Matisa. Who is that gift Matisa?
He works for Black Duck.
So it is not correct that you were communicating with the first accused?
No. Gift Matisa was writing correspondence to the permanent secretary, and those letters were copied to me.
Now, you confirm that up to now, the ministry has not yet written any letter demanding that the guarantor, either Medbank or First Capital, reimburses it for the loss that we have highlighted to this court.
I don't know, because I'm no longer working for LPD.
Okay.
I'm working for another department, and I'm not dealing with that thing.
Okay. And you also agree that the ministry did not report Black Jack to the law enforcement agents for failing to deliver the goods?
I don't agree. I didn't say that, and I don't know that.
You don't know that. The first accused will tell the court that it is that realization by the ministry is that the cost build-up that I was reading to you is how the money was used. That's why they have not even written to Blackjack asking for a refund up to now.
I don't know that, because as far as I'm concerned, the price that was given should cater for all the cost build-ups.
And that is the price of $175 per go trial.
No, I disagree with that price, because what I know is the first contract price for Matebelo goods were in the region of 200, and that for Mashona was in the region of 99 and 95, not 175. The addendum or the reviewed price is the one that went down for Matebelo goods in the range of, say, 160 to 170 there, and for the Mashona goat, it went down by 25%. However, I can give you the actual figures.
And the accused person number 1 will also say that the failure by Blackjack Private Limited to be tax compliant and to be NASA compliant did not influence the number of goats that were delivered to the ministry. Can you dispute that?
No.
Wait. Can you put the question?
The failure
Yes, proceed.
to be tax compliant or to be NASA compliant did not in any way contribute to the failure to deliver the number of goods required by the ministry.
I can't comment on that one, because I didn't know Black Death had some shortcomings with other companies.
Your answer? What is your answer?
I have said I am not aware that Black Deck had some shortcomings or its papers were not in order.
Please proceed, Mr. Kuto.
Okay, that was the finding by the court. Now that you know, I want you to answer the question using your experience as the person who was working in the livestock department, heading that department in the ministry. Would that have played any role in the procurement of the goods?
If I had known that the papers were not correct, then I would request for the procedure, for the due process to be redone.
Yes, because the first accused would say, in terms of the procurement regulation, if the papers were in order, they would have been given a specific time to correct the anomaly. That's what you are talking about, right?
In short, let me say, if you are conducting business, you have to do it properly. As long as you are doing shortcuts, then there is a problem. And in my capacity, I would not accept documents that have got a shortcoming or that are not proper.
That aside, I mean the procurement, the actual purchase of the goods.
Yeah, but how can we proceed to procure goods when papers are not in order?
You are not asking me the question.
Yeah, yes, I have to ask you questions.
In other words, you are saying that it was impossible for Black Day Private Limited to buy goods when it was not tax compliant.
You see, the reason why the witness seems to be arguing with you is that you are putting argument to him. That is argument. If you are going to submit that the fact that the papers were not in order did not affect delivery or could not prevent Black Tech from delivering goods, it's your submission, which should be submitted to court. But if you are inviting him into an argument, he thinks that there is no need to talk about performance of anything based on wrong papers. Why don't you leave that for submissions?
Well, I will leave that for submissions. Now, in your statement, you give the impression that the raw folk were so much disadvantaged, impoverished by Black Deck's failure to provide the goods, right?
Yes.
The first accused told the court that it is because the ministry abandoned the project midstream and not that they are the ones who failed.
Yeah, but the same contractor had an agreement in 2023 to provide goods, and they did that. That I find a serious mismatch.
If I may confirm my claim. That is all.
Mr. Majuku?
Yes, my lord. My learned friend is in here. Will do the
I will not be long, my lord. I will just be short in my cross-exam. Now you conclude that in your assessment that there was so much prejudice as a result of this offense. Do you agree with me that your findings are not based on any scientific study? It's just your own opinion that you are giving to the court?
It's not my own opinion. Why do I say that? The figures that I used to calculate the prejudice is based on data, information collected by Ministry of Agriculture in their crop and livestock assessments. And one of the documents is this one. Specifically, the kidding rates, the kidding percentages, the winning percentages, the off-take rates are contained in this document. And that was the basis. Those production and productivity figures are contained here.
I see. Now, what has happened to the presidential goat scheme currently as we stand here in court?
I don't know because I'm no longer working there.
So you do not know whether or not it is still in existence, it has been suspended or cancelled?
No, you say it right now.
Yes.
And right now means I should be knowledgeable of what exactly is happening. And I am working in another department.
Yes, Ms. Minduro,
Yes.
you still answer you have not answered my question. Can you tell this honorable court as a matter of effect to say that the presidential scheme as we stand here in court has been suspended or it was cancelled as a scheme, the whole scheme?
Yes, from the talks that I hear, there is nothing going on. But I can't say with concrete facts,
Precision.
that this has been stopped or it's still going on.
No.
Because I was actually shocked to hear that in 2023 there were some goals, there was some communication between the company and Black Deck, and there were some deliveries. I was not aware of that.
No.
That's why I'm saying I am aware of the activities up to end of January
It's okay,
2023.
Ms. Minduro, you've answered me. During the time that when did you leave the Ministry of Lands?
I didn't leave Minister of Lands. I was with him, but I was reassigned
To another department?
Yes.
Oh, okay. Before you left the department that was responsible for the presidential scheme, when was this? When you were still there?
That was the end of January 2023.
2023?
Yes.
Before you left, was there ever a report that was produced by the Ministry of Lands as regarding the implementation of the whole presidential goat scheme?
As ministry,
Yes.
I don't know. But I produced my own report that I submitted to my principals.
Okay. So you confirm that you are not aware of the existence of a government report on the assessment and the implementation of the goat scheme as a whole?
No, not at the moment.
You are not aware of it?
No, the one that I know is the one that I produced and forwarded to my principals.
Okay. What I want to know from you is, why do you conclude in your evidence that you gave to this court that the goat scheme was then suspended as a result of the offense that was committed by these accused persons?
Yes, thank you. It was my communication, the last communication that I did with Moses Mpofu. He wrote to me, he sent me a WhatsApp and said, we have suspended the project pending the legal route. And then I wrote this to my principals, advising them. And I also responded to Moses Mpofu, and I have the WhatsApp, I have everything. that thank you for the communication that you have advised me, that you have suspended delivery of goods.
Oh, so the suspension that is contained in your statement or in your affidavit is only limited to the agreement between Black Deck Private Limited and the Ministry of Lands, not the whole scheme, the whole presidential gold scheme.
I don't want to be misquoted. I work for the ministry, and when I am referring to this project, whether it's between Black Deck or it's between, I communicate with the relevant person.
Okay. So,
And in this case, that was Moses Mpofu, whom I was communicating right from the word go.
So, am I correct, therefore, to say that it would be wrong for anyone to tell this honorable court that the presidential gold scheme as a whole scheme was suspended or cancelled because these accused persons had misappropriated the funds?
It's a little bit tough for me to make that conclusion, because there were a series of events that took place that where I was not involved, and communications were happening in terms of the issue regarding price, and there were other issues that were taking place.
Witness,
That I was not
that's all
involved.
on there. Do you admit that if there were any challenges that were faced by the presidential gold scheme, as a whole scheme, there could be other several challenges that, or other problems that were mad around that project, not necessarily because these accused persons misappropriated those funds. There were other challenges or other issues outside of accused persons' misappropriation of funds.
No, I didn't pick your question there. Can you come again?
What I'm asking you is, if there are any challenges that were faced by the presidential gold scheme, as a whole scheme, there could be other reasons for either its delay in implementation, its suspension, or its cancellation, which may not have to do with the misappropriation of funds by accused persons.
Yes. Yes.
My Lord, I have no further questions.
Do you want to re-examine the state or? I thought, Mr. The silence would have disturbed you.
I just want to just have one question in our examination. What factors were considered in arriving at the cost price of a court?
If, as you have asked me, I don't know. But when someone is coming up with an estimate, I consider that he will go through all the necessary steps up to the end when the product is delivered. And one makes a cost builder. And when one makes that cost builder, that will be the price of the product. And that is the price that will be used to calculate the quantity that is required. And I'll go further. I find it a little bit ridiculous that I should be told that we bought this, we did this, we did this, we did this. No, I'm not interested in that. That's your defense that you should have done when you went for the adjudication, when you were doing the tendering process. When it comes to me, the price of the court is this, and this is the product that we are going to get. period. Thank you.
What I wanted to ascertain is whether the cost price of which goat does it, what does it involve other costs other than the goat itself?
When we talk the cost price of a goat, it depends on the vendor. You could be buying a goat from this point and delivering it to that point. And if the cost of the goat is $30, and you are just moving it to a point which is about a kilometer away, you might just include about a $5 increase because you have no a lot of cost to incur.
Yes.
But the assumption is, when someone tells someone the cost of my product is this, I assume you have incurred the cost build up.
I have no further question for the meeting.
Thank you. Thank you, Mr. Mendoza.
Thank you so much.
I hope this is the last time we are inviting you.
Your Honor, am I allowed to leave? Or
Yes,
I have to?
yes. I don't know. It's up to the state.
Thank you.
So you can go.
Thank you so much. Thank you, everybody.
What are we doing next step? State, we are now going into mitigation.
Indeed, my lord.
Thank you.
The mitigation, the defense would like to call the evidence of first accused person with Mpofu.
Sitara ngundonzi most Mpofu.
Ndaushandisa kutaura kudai.
Tata nation.
Moses unopika here kuti uchakufa muchataura mudai. Changoro chokwadi chisei pasina chimonzi kwechokwadi. Kana muchipika mosudza roko rwerudyi moti ndinopika mwaribatsira.
Ndinopika Mwari ngavandibatsira.
The witness is under oath, my lord.
Yes, thank you. You can proceed, Mr. Koto.
Witness, you confirm that you are one of the directors for Black Private Limited.
Munosigirira kuti muri vamwe vemadirectors eBlack Private Limited.
Oh.
Yes.
And it is common cause that Black Private Limited received 1.6 billion Zimbabwean dollars in terms of the port procurement scheme.
Izvo zvisiri kupikiswa ngare kuti Black Private Limited yakapiwa 1.6 billion Zimbabwean dollars kuti muite chirongwa chembudzi.
ichokwadi yakapiwa 1.6 billion RTGS ndorete currency yaishandiswa panguva yacho.
It is correct that it received 1.6 billion RTGS, which is the currency that was being used at the time.
Now, the state alleges that that 1.6 billion was meant to benefit 120,000 households in terms of goods, and were supposed to have delivered 126,400 goods from the amount that you got. What is your comment?
Vanotosara kuti imari 1.6 billion ingaifanira kunge ichibatsira dzimba dzinosvika 120,000 uye zvakare maifanira kupa 126,400 goods dzimba idzi inoti chinazvo.
Izvozvo handisi kubvumirana nazvo nekuti initially Black Tech Private Limited yanga yarequesta Minister of Agriculture kuti ibhadhare 70%.
I do not agree with that because initially Black Tech Private Limited had requested for the Ministry of Agriculture to pay 70%.
70% yanga iri total contract value.
The 70% was the total contract value.
Contract value yacho yanga iri 87 million and something in US dollars payable at the RTGS rate.
The contract value was 87 billion and something US dollars payable at the prevailing RTGS rate.
Yes, did it pay?
Vakabhadhara.
70% yakazonegotiatwa to 30% tikawirirana kuti ikubhadharwe 30% yacho.
The 70% was negotiated to 30% and we agreed that they were to pay the 30%.
30% iyoyo ndiyo yaifanira kubhadharwa mushure kwekuti Black Tech yaprovida Ministry of Agriculture ne-advance payment guarantee from a registered commercial bank.
The 30% was supposed to be paid after Black Tech Private Limited had provided the Ministry of Agriculture the advance payment guarantee, which was supposed to be provided by a registered commercial bank.
Advance payment guarantee Black Tech Private Limited yagai raiser ne Metropolitan Bank.
And Black Tech Private Limited raised the advance payment guarantee through Metropolitan Bank.
And my conditions guarantee yangari kuti 30% iyoyo yaifanira kubhadharwa in full as per contract.
The conditions of the guarantee was that the 30% was supposed to be paid in full as per the contract.
Asi Ministry of Agriculture aina kukwanisa kubhadhara Black Tech Private Limited 30% iyoyo.
But the Ministry of Agriculture did not manage to pay Black Tech Private Limited the 30%.
Mari yakabhadharwa yanga iri 1.6 billion RTGS yanga iri pasi pe 10%.
The amount that was paid was 1.6 billion RTGS, which was below 10%.
Saka neizvozvo Black Tech Private Limited yaisakwanisa kusupply mbudzi dzinosvika idzo 120,000 semabvunziro amamaita.
Because of that, Black Tech Private Limited was not able to provide the 120,000 votes which you had asked about in person.
Okay. Now, did your was it provided for in your contract as to how the initial disbursement was supposed to be used?
Zvanga zvanyorwa nemupachipungano chenyu kuti mari yekutanga maipiwa yaifanira kushandiswa sei.
Pasina kunyorwa sekudaro asi contract yedu yaitaura iyo kuti mbudzi dzofanira kugadzirirwa ma-infrastructure countrywide.
It was not stated as such, but our contract stated that there were supposed to be infrastructures which were put in place for the roads countrywide.
Uyezve kwakune condition yekuti mbudzi dzaifanira kuvaccinatwa.
There was also a condition that the goats were supposed to be vaccinated.
Pane condition yekuti
tender schedule cost.
My lord, this is not the stick is not proposed.
What is this document?
It's a schedule of expenses by Black Private Limited.
Yes, proceed. What exhibit would this be?
Yeah, that should be exhibit number 26.
Very well. By consent, the schedule of expenses by Black Tech shall be exhibit 26.
So, can you check us through that schedule of expenses?
You said it's a schedule of expenses by
Black Private Limited.
not Black Tech Livestock Poultry.
Well, according to the
I'm just reading what is written there.
well, that's their letter that they have continuously used. So, according to the witness, it says it's a schedule of expenses by Black Private Limited. That's why you got the document.
I read it. Yes, is it?
Yes, can you tell the court what that statement shows?
gwaro iri rokutaridza iro kuti rakabva kucompany inonzi Black Deck Private Limited.
This document shows that it came from a company called Black Deck Private Limited.
Trading as Black Deck Livestock and Poultry Farming.
Trading as Black Deck Livestock and Poultry
Where are you
Farming.
reading from? Where is trading as? I can't see it.
Balance trading is.
Panapa kunzi trading was, but ndaifa kuti inyaya yandakambotaura nezvayo nevanhu vekuministry vakaitaurawo kumashure panguva yetrial.
It is not indicated anywhere, but I did mention it before, and it's not from the ministry. Mentioned it as well.
Mr. Koto, I'm sure you know that you must guide your witness. You have asked him to read the record, the document into the record, and he must just read the document.
Okay, read from the top.
You want him to read through all that? All the figures up to the end?
Not all the figures.
Yes, so
He just to give a summary. Because I've given a commitment to my colleague that we are going to be done today that way. So he will
so
not.
why don't we just leave it as it is?
Well,
And then you just put to the witness why it has been produced. We will see it. We are seeing it.
Very well, my lord.
Just go to the point. Put it to him.
What
Let
is,
him to say what you want to prove.
Okay. What is the total amount of money received by Black Deck Private Limited?
Sandasvika ipapo nichatanga kumusoro mbichana pakanzi Black Deck Private Limited Presidential Goats Pass On Scheme Project Establishment and cost, operational cost. Payment received ikuratidza iyo kuti it's RTGS 1.6 billion.
The payment received is shown it's 1.6 RTGS.
Okay. And what is the amount of the total expenses incurred by Black Deck?
My expenses akashandiswa ne-Black Deck Private Limited achisanganisira vana bank guarantee
And that one, the total? What is the total?
total expenses yakashandiswa ne-Black Deck ari kusvika iwo pa2 billion 028,457,264.92.
So from these figures, if one says that we were supposed to have delivered 126,400, because what would be your comment?
Tikatarisa pa-total expenses mari yakashandiswa ne-Black Deck Private Limited ikutodarika mari yakawanikwa kubva ku-Ministry of Agriculture.
If we were to look at the expenses, the amount that was used by Black Deck Private Limited exceeds the amount that they were given by the Ministry of Agriculture.
Saka Black Deck Private Limited yakatozoshandisa dzimwe mari dzayo.
Therefore, Black Deck Private Limited actually used some of its own funds.
Ndosaka nanhasi ine zvikwereti kune mamwe ma-service providers yaishandidzana nawo.
That is why they still owe some debts to some service providers that they were working with.
Izvozvo zvakakonzereswa nekuti mari yacho yatakapiwa yanga isingatokwani zvakaitika zvacho, saka 120,000 goats zaisakwana zvachose.
That was caused by the fact that the money that we received was not enough for what was done, and it was not enough for the 120,000 goats.
How old are you?
Mune makore mangani kuberekwa?
Ndine 50 years.
I am 15 years old.
You tell the court about your marital status.
Names may be not great.
Ndakarora.
I am married.
Any children?
Nevane.
Ongu ndine vana vanoita 9.
I have 9 children.
How old are they?
Vane makore mangani kuberekwa?
Unotanga msikana anonzi Daniela Mpofu ane 25 years.
Yes, Daniela Mpofu is 25.
Yes, go ahead.
Msikana, and then koita Nomalanga Mpofu ane 21
Do we need
years.
the names, Mr.
Well,
Court?
you don't have to specify the name. Just first one, 1, 2, 3, up to now. What are their ages?
Not all I must say, I will not person. So I want to understand.
Yes, you can tell the court how old is the last one?
What person are makore mangani?
Last born ane 6 years.
The last born is 6 years old.
Okay. Of all your kids, how many are in school?
Vana venyu vese vachiri kuchikoro vangani?
8 wekutanga ari kuuniversity.
8 and the first one is in university.
Bese ari kuprimary.
The last one is doing primary.
Okay. Who pays for their education?
Anobhadhira kuti vaende kuchikoro ndiani?
Ndini baba wavo.
I do, as the father.
Yes. Are you employed?
Munoshanda here?
Ndoshanda.
I am employed.
Where are you employed?
Munoshanda kupi?
Ndoshanda ku-Black Tech Private Limited. Ndoshandawo futhi kuprazi tinorima tine family farm.
I am employed at Black Private Limited. I am also employed at a farm, which is a family farm.
Rinova iro farm rangashandiswa for the project richirentwa ne-Black Tech Private Limited.
Which is the farm that was being used for the project being rented by Black Private Limited.
Approximately how much do you realize per month?
Ngati pamwedzi inowana mari.
Ndichiri kunze ndaikwanisa kuwana between 10 and 15,000 per month.
When I was out of custody, I was earning between 10 to 15,000 a month.
But now, are you generating any income?
Pari zvino pane mari here yamukuwana.
Mbichana ndowana but zvakaoma.
I'm earning a small amount of money, but it is difficult.
When did you get into custody?
Makapinda musunga rini?
Apinda musunga mswa 26 June 2024.
I went in custody on the 26th of June 2024.
Okay, what was your benefit, your personal benefit from the gold scheme?
Imipata zvino makawanei kubva pachirongwa ichi chemurudzi kana pane chamakawana?
Mangotiwo ndakawanawo salary nema-allowancewo semunhu wekuti kana ukabuda kunze nebasawo unowana ma-allowance tinowanika.
I would say I received a salary and some allowances as a person who would travel for work purposes.
Now, it has been found that Black Tech Private Limited was not tax and NASA compliant. As the director of that company, would you know the impact the lack of compliance had on the procurement of the goods?
zvakudangara kuti blackjack private limited yanga isiri kutedzera zvinodiwa pakugadzira mitero nenasi saka munoziva here imi musadirector kuti zvinokonzeresa chii pakambani?
Sorry, what is the question?
I mean, as a director, would you know what impact that had on the ability or capacity of the private limited to acquire the goods?
Imimi sadirector mungazive kuti zvakaita sei private limited panyaya yekuzokwanisa kuwana mbudzi?
semaziviro andinoita semunhu anga ari paground hazvina kuva neeffect kana kawani nekuti vataitenga mbudzi hakuna kwaishedzerwa kudzitanga imatipa tax clearance kana nasa certificate.
As the person who was on the ground, I observed that it did not have any impact at all because there was nowhere from the service providers whom we acquired the goods from, where we were asked for tax clearance or a NASA certificate.
So what caused the failure by Blackjack Private Limited to supply the number of goods expected by the ministry?
Saka chii chakakonzera kuti Blackjack Private Limited itadze kuzoendesa mbudzi dzanga zichidiwa neministry?
Nyaya hombe yakatadzisa Blackjack kuti ikwanise kufulfilla manumbers aidiwa. Number one, inyaya yekubhadharwa sekuwirirana kwakwaitwa pacontract.
The first issue which caused Blackjack to fail to supply the goods as required by the ministry was the failure of the payment which was agreed on the contract to be supplied or paid.
Yes, nekuti since project yanga iri a 5-year program, Blackjack Private Limited yakaita an implementation plan.
That is because since the project was a 5-year program, Blackjack did an implementation plan.
And implementation plan ye Blackjack yaireva kuti iyo dzimwe mbudzi dzekungo kickstarter project yaitenga kuva farmers.
And the implementation plan meant that Blackjack was going to buy the goats to give some of the goats to kickstart the project from farmers.
Ichipa Minister of Agriculture.
And would then give them to the Minister of Agriculture.
At the same time, Blackjack Private Limited yanga in a long-term plan yeku breeda mbudzi ichishandisa the main farm ravaishandisa for the project Colenso farm.
And at the same time, Blackjack Private Limited had a main plan where they would be breeding goats using the farm which they were using, which is Colenso farm.
Saka yaitarisira kuti breeding exercise yaizospreada kumamwe holding centers ayo vachiwana mbudzi dzavo and then vochisupplya ministry nembudzi dziri kubva kubreeding.
They were expecting for the goats to spill over from the breeding center to other holders, where they would then supply from them to the ministry.
Okay, can you tell the court what you have just explained, how did that impact on the capacity of Blackjack to supply the goods?
Saka zvomatsanangura izvi zvakaita pane kukwanisa kweBlackjack kuti ngecheresa mbudzi.
Izvozvo ndingatoti ndo chikonzero chihombe chatakasangana nacho nekuti mari yakabhadharwa pekutanga inosvika iyo 1.6 billion yakawanda yacho yakatoenda towards setting up yechirongwa ichocho chekuchengetera mbudzi pekubhridhira nezvimwe zvakadaro daro nevaccination.
That is the main issue that or main difficulty that we faced, because most of the 1.6 billion that we received went towards preparing the place to keep the goats as well as the breeding place for the goats.
saka taishandisa 1.6 billion semashandisiro atakaita atanyora ipapapo tichitarisira kuti kune imwe mari yataizowana nekukasika semaudzirwo atataitwa nemarepresentative eMinister of Agriculture.
We were using the amounts that we had received in the manner that we explained, expecting to receive more money in a short space of time, as had been promised by them last year.
Did Black Private Limited receive the money as promised?
Blackjack yakazowana mari here sekuindiswa kwamakaita.
Blackjack Private Limited aina uzombovira yawana mari and ndozvakatoifeedza zvakatoisiya nanhasi iri mumadambudziko ezvikwereti.
Blackjack Private Limited did not receive any further money. That is what caused the disturbance and left it in debt.
Okay. There is a clause in the contract between the Private Limited and the ministry, which provided for a dispute resolution mechanism. I want you to tell the court whether you Blackjack ever received any correspondence from the ministry to the effect that it was in breach of the contract at any point.
Spanish company contract in the ministry. Chinotaura maererano nekugadzisana kana kuti munenge masvika pakutadza kunzwisisana zvaifanira kuita pakugadzisana. Pane here chinyorwa chamakawana kubva muministry chaitaura kuti mii makatadza kusatsikisa zvaidiwa pachibvumirano chamanga maita neministry.
Chinyorwa chiripo chakabva kuministry musi wa21 August 2022 kana nisiri kukanganisa.
There is some correspondence from the ministry which came
21 August 2022.
Which came on the 21st of August 2022.
Chinyorwa ichi chaitaura icho kuti Ministry of Agriculture yakuterminate a contract for their convenience.
The correspondence was stating that the Ministry of Agriculture was terminating the contract for their convenience.
Isusu takatina kutora nguva takabva tapindura tsamba iyoyo through malawyers edu.
We did not take long. We responded to that letter through our lawyers.
Okay, good. Prior to receiving the 21 August letter, was there another communication from the ministry alerting you or alerting Blackjack that it was in breach of the contract?
Msati mawana tsamba yemusi wa21 pane here imwe tsamba yakabva veministry vachiisisa kuti manga machikora chikontrakt.
Ayo.
No.
What is the status of the project right now?
Pari zvino iyi project yakamira sei?
Project yakangomira sezvatirimo mumadare yakangomira handizoziva kuti kunze kwakamira sei, but from zvandinoziva ndezvekuti for now project hapana.
The project came to a halt since we are in custody, and I do not know the stage at the moment, but from my knowledge there is no project.
And so who is responsible for the current status where you are saying there is no longer a project?
Saka akatangaza akakonzesa zvazviri pari zvino pamukuti akatorina project ndiyani.
Sorry.
Who is responsible for the current status where you are saying there is no longer the scheme?
Akaitisa kuti zvive zvazviri pari zvino kuti zvamukutaura kuti hapasisina project ndiyani.
Inini semafungiro nemaonero angu project yakamiswa nekutadza kweministry kufulfilla zvatatawirirana pacontract neBlackjack Private Limited.
From my observation, the project came to a halt because of the failure of the ministry to fulfill what we had agreed with it as Blackjack Private Limited.
Okay. The witness who was on the witness before you came, you were saying you communicated that we were now suspending the supply of what tell the court, highlight the court as to what exactly transpired.
Pakazauya mudara angari mudara taura kuti imi makataura kuti makumbomisa kuendesa mudzi makataura izvi zvakaitika.
ichocho ichokwadi sezvo inini ndina ndiri paground sezvo ndakambotaura kuti ndina ndiri responsible for implementation.
That is correct, because I was the one who was on the ground. As I had mentioned before, I was responsible for implementation.
And iyo do position yanga ari kuministry ndiyanga ari paground yekureceiva mbudzi through vanhu vake vekuministry throughout the country.
In terms of the position that he held at the time in the ministry, he was the one who was responsible for receiving the votes from his subordinates in the ministry.
Okay, why were you threatening to suspend the votes, the delivery of votes?
Same opportunity, Mauda Munisafende Sambuts.
Chakakonzeresa kuti tidaro kune communication yaiitwa neBlack Tech Private Limited ichitsvaga mari yakasara kuti iuye tikwanise kuenderera mberi neproject, and mari yacho yaisawe pakawanda pacho ministry yaisatomboresponda kumatsamba inyorwa neBlack Tech Private Limited.
What caused us to do that was because there was some correspondence whereby Black Tech was trying to acquire their outstanding amount from the ministry, and at times they would not even respond to the.
Was it before or after cancellation of the contract?
Chivumirano chachatokanzura udhara.
It was after the cancellation of the contract.
And was what year was that?
Anga iri 2022.
It was in 2022.
Towards the end of the year.
Towards the end of the year.
November or December.
It was in November or December.
So that's when we threatened to suspend the supply.
Ndizvozvo nekuti taida kuti ministry itipe attention titaurirane tione kuti way forward tingaite sei.
That is correct, because we wanted the ministry to give us their attention so that we could discuss the issue and see the way forward.
Okay. When did Black Tech last supply the goods?
Black Tech yakapesera kuendesa mudzirini.
Black Tech yakazonyorerwa tsamba musi wa6 June 2023.
There was a letter that was written to Black Tech on the 6th of June 2023.
And mutsamba iyoyo Ministry of Agriculture yaikumbira Black Tech kuti isupply mbudzi 500.
And in that letter, the Ministry of Agriculture was requesting for Black Tech to supply 500 goats.
And pekupedzisira kwetsamba iyoyo ministry yakabva yataura kuti while we are still engaging kuti tigadzirise contract yedu tienderere mberi nebasa chimbotipai mbudzi 500.
In that letter, or at the end of the letter, the ministry stated that while we were still engaging to rectify the issue of the outstanding amount, we could supply them with 500 goats in the meantime.
Black Tech Private Limited board rayo rakagara rakaitwa resolution yekusupply mbudzi idzodzo.
The Black Tech Private Limited board set and did a resolution to supply the goats.
Mbudzi idzodzo 500 dzakasupplyiwa musi wa16 June 2023.
The 500 goats were supplied on the 16th of June 2023.
Those are the needs in the road and grenade assistance.
Do you intend to put any questions to him?
Yes.
Yes, proceed.
Thank you. Mr. Mpofu, it is common cause that the 1.6 billion that you received from the Treasury through the Ministry of Agriculture was all offloaded onto the informal market, onto the black market.
So it's got 1.6 billion amakawana mpita ni Treasury. Ye Ministry of Agriculture, yes, again this one the market.
Achischokwadi.
That is not true.
during the trial, we went through your bank statement, and all the money was removed, was transferred from the bank account into the black market, where you said you were trying to gather foreign currency in order to run the project. Is that not the position?
Isatina pindura mvunzo wenu vamuchushisi. Nichatangira pa item number 1 yema expenses.
Before I respond to that, I will start with item number 1 of the expenses.
No, answer the question. I've asked you a specific question and answer the question. I haven't gone through the list of expenses.
Aiwa chisichovadi kuti mari yese yakaenda kublack market uyezve handina kuti mari yese yakaenda kublack market. Ndakataura kuti kune imwe yakaenda kuma-guarantees, imwe yakaenda kuma-agents. It's on record.
It is not true that all the money was of the black market, and I did not say that. Some of the amount went to guarantees and the other amount to agents.
Dzimwe mukataura mega kuti yakaenda kuvanadzvetero kuma-legal personnel.
And you said yourself that the other amount went to
Saka
the legal personnel.
ikoko akusi kutenga mari mu-black market.
That is not getting money from the black market.
Now, in relation of the expenses, like the dam building, dam construction, construction of roads, etc., hiring of bikes and vehicles. Why is it that all the expenses are in RTGS, yet we had converted the money into US dollars?
Say zvinhu zvezvaitwa nema-RTGS asi mimamachinja mari kuti iye mari yekunze.
Mari iyoyo kana ichirangarira mutemo waiti even ukabhadhara iri US dollar kana kuti taibhadhara even kana patabhadhara munhu iri US dollar pamwe taibhadhara ne-RTGS, chero wabhadhara ne-US dollar maiwirirana rate moinvoisana ne-RTGS. Ndosaka mafigures edu ese ari mu-RTGS, nekuti handina kuda kuti ndikupei marate ataitenga nawo ma-US dollar aya aitozokuvhiringa izvo kuti maisawirirana nazvo.
Correctly, during that period, it was agreed that every purchase was supposed to be done according to the prevailing rate. So it had to be recorded in RTGS even if you were to buy in US dollars. So all the transactions were recorded in RTGS. And if I were to state the rate at that time, it would confuse you.
Now, all the dam construction, the road construction, and so forth, they took place at Colenso Farm.
Hazvisiri izvo.
That is not correct.
Where did you construct the dam?
Makavaka dam.
Demu iri harina kuconstruct. Demu iri takati i-reconstruction, idemu rakara ranga riripo.
The dam was not constructed.
Saka wakuri kurehabilitator chinhu chiripo nekudhara.
Okay, it was reconstructed because it was already there.
Where did you reconstruct the dam? Where is the dam located that was reconstructed?
Riri paColenso Farm semanyorerwa pazvakaitwa.
He said Colenso Farm as it is written.
And the roads?
Koma Road.
Road construction yakaitwa iri rehabilitation kuColenso Farm nemamwe ma-holding areas atairenta.
It was, the roads were done as a rehabilitation of roads at Colenso Farm and other holding areas.
So effectively you are improving your own property.
Support my ingogadzisa nzvimbo yenyu.
Black Tech Private Limited mahairo kana kuti marentero yakaita plus ndepekuti pamwe pacho nzira dzacho dzakafa dzakadamejeka and pa agreement yatakaitirana neBlack Tech Private Limited ma-improvements iwayo vaimada kuti vakwanise kuti project yavo ifambe zvakanaka.
When Black Tech Private Limited rented the premises, some of the roads were damaged. And as per our agreement with it, they needed to improve those roads so that they could do their work properly.
And the roads and ndikutaura aya asi maroads ekuti akaiswa tara gravel roads aingogredwa oiswa backfilling ongogadziswawo kuti angova smooth.
And at these roads that I'm referring to were not tarred, but there was gravel which was put and backfilling so that they could be used.
Now, Mr. Mpofu, do you accept that the expenses that you just placed on this list, they are meaningless without invoices and receipts that you received when you made the payments, because one can easily come up with list of expenses from your head, from yourself, which are unsubstantiated in the absence of backing documents.
Munostigrere kuti zvinhu zvamukutaura zvakabuditsanganizve hazvinazvo zvinoreva kana pasina mareceipts nemainvoice zvinhu zvamaitenga nezvamaiita zvacho nokuti munhu anogona kungonyora chinyorwa chokutaura kuti ndakabudisa mari yakati.
Izvozvo handisi kubvumirana nazvo zvachose nekuti mabank guarantee for example irimo mubank statement, mabank charges anozivikanwa arimo mubank statement.
I don't agree with that because, for example, the bank guarantees and the bank charges are in the bank statements, they are not.
Militech Private Enterprises Private Limited yakabhadharwa 200 million zvirimo mubank statement.
If you may move on to those items like to do with bank construction, road construction, rental of holding areas, hire of project vehicles, hire of distribution vehicles, fuels and so forth. In the absence of any document to support what you are saying, this cannot be. Do you expect the Honorable Court to accept this on face value?
Kana pasina magwaro anotsigira kuti ndo zvakaitika kuchitazira kudai ndingogamuchira kuti neti machitaura.
I think mabvunziro enyu maifanira kunditi zvimwe zvacho tikuda kuti zvive neevidence yemapepa asi zvimwe zvacho zviri clear. Toona kuti pasiri clear kwamuri ndepapi ndoona kuti ndopatsanangura sei, but apa mukutaura senge zvese zvakanyorwa apa ndezvekunyepa.
I believe you should have said that some of the items or some of what is listed needs documents and some does not. Because from what you're saying, it seems as if everything that I've said is not true.
No. Now, where documents are required, why haven't you produced such documents? Yet you are running a business which is registered in terms of the laws of this country.
Panodiwa kuti pange pane magwaro semusina kumaunza sezvo muri kuita bhizinesi rinoita maererano nemitemo yenyika ino.
Magwaro iwayo aripo, ndogona kumarequesta kuBlack Tech kufinance department. Pari zvino ndini ndakatorequesta statement of expenditure iyoyi ndikapiwa iyoyo, nansina kurequesta ma-invoice nema-receipts, asi kana zviripo ndaizvizadza panapa zvese zvowe kana na.
Those documents are available. I can request them from Black Tech Private Limited Finance Department. I'm the one who requested for this list of expenses.
Yes. I'm sure you would appreciate that supporting documents which gave rise to these listed amounts would have been helpful in proving that indeed you incurred such expenses.
Nazvo kuti magwaro anonatsoratidza kuti ndozvamakaita aizobatsira kuti mukwanise kubuditsa pamberi pedare kuti zvechokwadi mari dzimakadziburitsa.
ichocho ichokwadi andina chirambe and magwaro iwayo aripo anogona kurequestwa ouya osapota zvakanyorwa panapa asi
That is true, I cannot deny that, but the documents are there to support what is written.
Now, when in the main trial, when we went through your bank accounts, when the money was initially deposited into your company in April of 2022, you had a negative balance. At the end of June, when the second amount was deposited into your account, you had a negative balance, which was all deducted from that account. And you want this honorable court to believe that you made expenditure in excess of the amount that you got from the government of Zimbabwe in furtherance of the project, amounting to over 400 million. Is that your quotation?
ichokwadi nekuti sematauriro andakaita pa trial nchipa umbowo panguva yatatiri ndingati yanga iri nguva yakaoma senyika, mari yedu yailuza value zvinotyisa every day. Saka waingoti mari ichipinda sekambani totsvaga kuri kuda kubhadharwa zvinhu ne-US dollar, of which ndosaka mchiona ma-agents sorry ne-RTGS dollar. Saka mchiona ma-agents akabhadharwa direct ma-RTGS nekuti mari iyoyo yaiti ikarara musi mumwe chete chaizvo rate yayo inogona kudonha kana ne-20% or more.
That is correct, because during that period we were in a difficult state as a country. So the rate was a change rate, an alarming rate, and you would see that whenever the money was deposited, the agents would be paid directly. That is because if the amount would spend or would be overnight in the day, the rate might even drop by 20%.
Mr. Mpofu, I think you didn't understand my question. My question is, you said, according to the statement that you have submitted, that you overspent in furthering of the project to the tune of 428 million RTGS. But when we went through your bank account during the trial, the only money that was ever deposited into your account was from the government of Zimbabwe for the project. Where was this extra money coming from?
Makashandisa mari inokwanisa kudarikidza kusvika 428 million pakubhadhira zvinhu zvaidiwa zvichidarika pane mari yamanga makonika. Saka pachitarisa mari mubhenki main account menu mari yaingoiswa yanga iri yaibva kugovernment. Saka imwe yamuri kutaura nezvayo.
Ya, ndakunzwai. Ndofunga pamusiri kunzwisisa kana kupaona ndepekuti Black Tech Private Limited haina account one. Ndosaka mchiona Black Tech Private Limited yakapa Ministry of Agriculture imwe bank guarantee inobva kuFirst Capital Bank, and haisiriyo chete account yeBlack Tech Private Limited, ine mamwe ma-accounts, ine mamwe mabasa inoita. Ndosaka yakapiwa bank guarantee neFirst Capital nekuti vanoiziva kuti company iri credit worthy.
I believe it was what I'm saying. Black Tech Private Limited does not have a single bank account. It has several bank accounts. That is why they were given a guarantee by First Capital Bank, and they also have other accounts other than that.
Anyway, I'll move on. Now, do you accept that a goat is not worth 90 US dollars? Or 85 US dollars, right?
I think 90 US dollars and 85 US dollars.
Ndoziva kuti mutengo wembudzi unogona kutodarika ipapo. Mutengo wembudzi unogona kusvika kana 1000, but isusu taitenga zvinoenderana nezvaidiwa necontract yedu pama-specifications embudzi.
I do accept that, that the price of a goat is not $85 only. It actually may exceed that amount, even up to 1,000. But we were acquiring according to what was required in the specifications that we get.
I'm talking about a Mashona goat that can go for $30, $40. Is it the position that they were built in, there were costs that made it necessary for the price to go beyond the $40, $50 to as much as $85 that you then quoted in relation to the tender?
So what I wish Mashona goat anoita $30 kana $40. Pane zvimwe zvaifana kushanda mari panero nekutenga mudziyo kuti aigona kuzodada kusvika $80-85 zvamainga muchitaura nezvazvo zvakamaridza.
Partly ndobvumirana nemi pakuti mbudzi unogona kuitenga panguva yacho iyoyo ne$40 US dollars cash, $40. Asi kwatiri yanga isiriyo nyaya yacho. 1, number 2, kozi yedu mari kana iri $40 ukaenda kana pambudzi kana patinwa kuti unosvikobuditsa mari wotonza mbudzi yako oenda nayo. Asi ukauya une ma RTGS kana eco cash panguva yacho kwaipiwa a rate iri premium yekuti ukaiweka wega unoona kuti mbudzi iyi watoitenga nemutengo wakanyanyisa wakawandisa.
Okay, that you can actually purchase a goat with $40 cash right at that moment. But in our case, if you were to go and buy a goat, you would use the RTGS currency.
What I'm trying to say is that in order to arrive at a higher price per each goat, we have to factor a number of things like transportation, vaccination, cost of looking after the goats and so forth. That's why the price of the goat was high. Is that not it?
Andizvere kuti kana mukatenga kuti imi maitira nyaya yekuvaccinata kwacho, kufambisa kwembudzi yacho, zvakawanda nepekugara zvakawanda wanda kuitira kuti isvike kana pamutengo uri pamusoro kana $85.
Ndoda kuti tinzwanane pakuti mbudzi actual price yedu yembudzi apa yanga iri pa $139 US dollars panguva iyoyo.
I'd like us to understand each other that at that time the price of the goat was $139 US dollars.
Now, if I'm not being specific to the prices in question, I'm just saying the number of costs that are factored in order to come up with the price per goat.
Kungotaura kuti pane zvinhu zvomaita sezvakawanda zvinofanira kutariswa maererano nekuzosvika pamutengo wekuti mbudzi iyoyo ifanira mari.
Ndomo mapinduro andoda kuita kuti pa $139 US dollars payable at the interbank rate on the day of payment yanga iri mari yembudzi chete.
That is why I'm responding that the $139 payable at interbank rate on the day of purchase was just for the purchase of goat.
Taizoisa mari yetransport yanga iripo tatakaifactor in mutotal cost yedu. Saka taiziva kuti tatenga mbudzi yedu iri valued $139. Transport yedu chapatara takadai, vaccination yedu ichadai, matax yedu nezvese.
Would also factor in the issue of transport, vaccination, and tax after everything, come up to that total of $139.
Now, I think we are going there again. You want this thing to be unnecessarily long, Mr. Mpofu. The issue is that I put you that in every price per goat, the SP addendum is $85, including all other costs which were necessary to get the goat to the beneficiaries.
Addendum sezvambotaura addendum haina kumbobvira yaimplementwa asi price yandoudza inini $139 ndiyo yatakakota ministry, ndiyo price yembudzi kuti tiisvitse kwairi kudiwa, yavaccinatwa yaitwa zvese.
the addendum was never implemented. The 139 is the amount that you quoted to the ministry for us to supply the beneficiary after having considered the vaccination and everything.
And I put it to you that the money that you got from the treasury of over 7.7 million US dollars was supposed to bring goats which were over 85,000 from that amount, instead of the 4,208 goats that you supplied.
So what is it?
I'm saying for the deposit that you got of 1.6 billion RTGS, you only used about over 330 million in securing 4,208 goats. Yet you were supposed to supply over 85,000 goats from that amount.
1.6 billion amakapiwa muministry makangoshandisa 330 million kuti mutenge 4,200 budzi 4,208 pachinzvimbo che 85,000 dzamamuchifanira kunge muchipa muministry.
I think vamuchuchisi kune patikurasana toda kuti tive clear and ndoda kuti muzvizive kuti handisi kuda kuwesta nguva yedare. Inini it's in my best interest kuti nyaya ikasike ipere. Tanzwa nayo zvakwana yakufanira kuvharwa tione upenyu hwekumberi. Saka ndoda kuansai zvakajeka and ndoda kuyambirai kuti musasanganise ma-US dollars nema-RTGS zvichakukanganisai. Ndosaka tichirasana because mukubata ma-US dollars e-Black Deck Private Limited yayakatenga mu-black market, momadzora momasanganisa kuma-RTGS ashande zvichidaro.
I want to say that I don't want to waste the first time. I want the estimator to finalize so that we can proceed with that. And I think we are missing each other somewhere. You are mixing the RTGS that was given to Black Deck Private Limited with the US dollars.
Tikatarisa.
I'll put it another way. If that is how we feel, you supplied only 4,208 goats instead of over 85,000 goats. That the ministry expected.
How many did they expect?
It should be in excess of 85,000 goats from the 7.7 million United States dollars that you got.
7.7 million United States dollars. 4,208.
Ndichakurifeya imukuru pama-goat supplied pa-last column tichibva pa-total expenses i-1 2 3 4 5 tichibva kumusoro pa-total expenses kune goat supplied, number of goat supplied i-2,898 at a unit cost of US dollar 139 per goat at a rate of 585.0986 as at 9 September 2022 patakasupplya mbudzi kuchisuma pa-launch. Mbudzi idzodzo nanda kutopedza.
No, I wanted to say that the judgment is already there. That you only supplied 4,208 goats.
Ndopandoda kupinda.
And therefore you are not supposed to come up with new figures. That is already settled.
Ayo. All right, nchaita nchida iso. Waindadaro churches 2,898 plus 2,898 dzakaenda kuchisuma plus 1,310 dzakaenda kune mamwe maprovinces. Manhamba iwayo ari 2 mukamasanganisa anotipa figure inosvika iyo 4,208 goats dzatakasupply.
2,898 went to Sumba and 1,809 went to other provinces. So if you add them up, they'll reach up to 4,208 which is supplied.
Saka handisi kuramba kuti takasupply patime yacho iyoyo 4,208 goats, but pavalue ndopanda ndichida kukuratidzai kuti 2,898 goats dzakakosta Black Deck 238 million 690 235 million 690,588 dollars 25 cents. Saka already tikutaura dze 289.
Anyway, let me move on away from these figures. Mr. Mpofu, I put it to you that you are not contrite at all in the commission of this very serious case. That you got a contract that you were not supposed to get. You are not contrite at all because the papers that you use in relation to this NASA certificate of compliance and ZIMRA tax clearance certificate, they were forgery. We did not hear this court did not hear you being apologetic about the commission of the offense.
Certificate of compliance NASA tax clearance magaita zvekugadzira magwara zvinobiridzi saka mutadza kuti hamuna kutendeuka kana kuti kuzvishora pane zvamakaita
izvozvo handingadaro. Inini ndobvuma kuti the court's judgment is final and semutongo wandakapiwa necourt kuti ndabatwa nemhosva hapana pandamboti koti mandikanganisira pakati kana kuti pakati. Asi semunhu wekuti inini handisi lawyer handizive kuti zvofambiswa sei cause zvinhu zviya nanhasi mumwoyo mangu nemufungwa mangu handisirini ndakazviita zvinhu zveBlack Deck Private Limited and zvakaitwa sematauriro andakaita padefense yangu.
I am not saying that, and the court's judgment is final if they say that I have been convicted. I do not oppose that, but in my heart, I still insist that I did not do this. It was Black Deck Private Limited which was involved in all this, in the way that they did it.
And you were never heard in this court apologizing to the people of Zimbabwe about the commission of the offense. That prejudiced the very poor of the poorest people in this country, as indicated in the victim impact assessment report, that the goats were made for child-headed households. They were meant for widow-headed families. They were meant for people who were sick. You know, people who found a goat worth 40,000 to be a life-changing investment in their lives. You were never heard apologizing about it.
Itsa kuti vanhu varombo chaivo vekupedzisira vatadze kuwana zvaifanira kunge vachiwana. Hanzi mbudzi idzi dzaifanira kupiwa kune mhuri dzinotungamirwa nevana neshirikadzi nezvakare nevanorwara uye zvakare kuti mbudzi ye40,000 inowa chinhu chinotokwanisa kushandira upenyu hwavo. Saka kuti hamuna kumbosvika pamakakumbira regi pamusana pemhosva.
Ndotenda vamuchuchisi wenyu akanaka chaizvo. ndingati mashoko mamatora mukanwa mangu marongero anandazviita kuti ndichaadresa nyaya iyoyo semaadreserwa amamuchitaura cause apology chaiyo yagara yanga iri mupfungwa dzangu ichitangira kune mutungamiriri wenyika his excellency vamunangagwa but
I believe you took the words out of my mind because I had planned it in such a way that the apology was going to start from the head of the nation, that is Honorable the President, His Excellency.
But the apology to be forced out of your mouth because you were through with letting your evidence. This is what you should have started by doing, rather than coming up with figures justifying that the money that you expended on the project was meant for the people. Yet you are the biggest beneficiary. You are busy developing your own farm, which the dams will remain there, and the people, poor people, they will remain suffering. And we haven't, up to now, we haven't apologized.
aiwa ipapo vamuchuchise handidi kupokana nemi ndoda kudzokorodza nekutendai nyaya iyi ndandaiplanira kuti pekupedzisira panichabvunzwa kunzi une zvimwe zvekutaura here ndopana ndichida kuisa apology yangu zvakanaka-naka ndandisingakwanise kuipinza imi mandibvunza mumwe mubvunzo ndoisa apology asi apology mukandipa mukanwa chaiyo ndagara ndoda kupa apology kana mukandibvumira ndoenderera mberi ndoti
I planned that when I was asked if I had anything else that I wanted to say, that is when I was going to then give the apology instead of inserting it in the answers that I was giving to the questions. I was going to actually state it at the end.
But in a minute, what do you want to say in the apology?
For a minute.
Ini ndoda kuti mumhuri yeZimbabwe ndine urombo and I regret kuti program yemutungamiriri wenyika yakazobuda mabudiro ayo zviri kuita nhasi.
I want to say to the nation of Zimbabwe that I regret that the program that was implemented by the head of the nation came out in the way that it has come out today.
Inini Samosi Mpofu ndagara ndiri mwana anovimba nemaprograms enyika yedu nedirection yatinosapotwa nayo, indigenization nezvese zvatinoitirwa nehurumende yedu.
As a citizen of this nation, I have confidence in the programs that are implemented by the nation in the indigenization that is implemented for us.
Ndinoda kuapologiza kuti company yedu Black Deck Private Limited nema-directors ayo nema-shareholders havana kunyatsokwanisa kuverifya nekuita due diligence yekuti mapepa eNAS neZimra tax clearance certificate anga ari echokwadi here, and takamashandisa mukufunga kuti mapepa iwayo angari mapepa echokwadi. Uyezve nhasi mapepa aya ndiazoratidza kuti nekusanyatsotarisisa mapepa sekutaurwa kwazviri kuitwa mukoti kuti mapepa ndeefeki, isusu taifanirawo takabatsirana takacherechedza mapepa iwayo toona kuti anogadzirwa sei.
I would also want to state that the directors and shareholders of the Black Deck Private Limited did not do due diligence to verify the documents from NASA as well as Zimra if they were authentic, because it is being said in court they were not authentic, and we didn't end up using in the manner that they were used.
Some of you were given the judgment that you were clamoring for. You were convicted in your personal capacity, not in your representative capacity. It's not Black Deck that has been found guilty of this offense. You are the one who was found guilty for having committed the offense yourself, and you are not even apologizing in your first in your own capacity. You are still in denial.
Makanzwa mto wenyaya kukaitwa pambepedali ni makabatwa nemhosva sedungamunhu kwete makamirira Black Limited uye pari zvino muri kutaura apa muchitaura makamirira Black Limited kuti muchiri kuti zviramba kuti makabatwa nemhosva sedungamunhu.
Tofunga matangiro angu ndati inini saMoses Mpofu mukumbiro regerero kumhuri yeZimbabwe mune zvakaitika.
From the start, I started by saying I, as Moses Mpofu, am apologizing to the nation of Zimbabwe for what happened.
During your mitigation, you were never ready offering to restitute the amount, which the government of Zimbabwe lost.
Pane iyoyo vamuchuchisi ameno nenda kuda guidance yemagweta edu kuti atibatsire nebhengi redu nekuti mari yese yatakapiwa yanga iri covered neadvance payment guarantee yatakabhadharira in full and reactive and authentic.
I would like to be assisted on that by our legal representative because the money that we received was covered by urgent payment guarantee, and it was paid in full and it was reactivated.
Mr. Mpofu, there was no contract application. It was gotten through deceit.
Papa Stona Shibumran Chakanga Shoko Makachiwana Bukits and
Ipapo andidonyepa ndingaziye nenda kuda guidance yemagweta kuti tosifambisa sei asi
I would not want to lie, I do not know about that, but I would need guidance from the lawyers on how to go about it.
asi chivimbo changu chachiri chekuti ndosaka vakoto vambobvunza victim pavictim impact assessment kuti vakamboshanyira here bhengi vakanzi chii. Ipapo ndoziva kuti inini saMoses Mpofu as an individual ndichionesana nekambani yandinoshandira tine chido chekubatsira kuti bhengi kana mari ichida kuti idzoswe nemaconditions aripo iwayo bhengi rotionesa kuti zvinobatsirwa sei based on the advance payment guarantee.
I want to say that we have been asked from the witness concerning if ever visited the bank or not. I would like to say I would be advised by my legal representative on if there is a way that we can negotiate with the bank for the advance payment guarantee to be paid according to the conditions they are in given for investment.
But would you volunteer to restitute the money yourself?
Kana dare randiti ndidaro handingapokane nedare ndoona kuti zvingaitwe sei asi pachokwadi chizere inini handina mari yakadaro saMoses Mpofu pari zvino.
If the court were to instruct me to do that, I would see what can be done. But truthfully speaking, I, as Moses Mpofu, do not have money to that amount.
No. In your mitigation, you did not tell this court the properties that you have. You just mentioned that when you were outside, you could make about 10 to 15,000, but you did not tell the court about the properties that you own, which is important in mitigation. At this stage, this is what you should have declared. Why are you silent about the properties that you own, the cattle that you own, the goats that you own, your assets?
Ndofunga kujambwa cause hatina kunge tataura nezveizvozvo, asi mukandibvunza handingarambe kupindura semapinduro andingokuitai pamubvunzo yese yamuri kuita.
I believe it was an omission because we had not discussed about it. But if you ask me, I will answer you the same way that I'm answering.
What assets do you have?
Name it your own question.
And the number ndo ndingati mudziyo mukuru wangu yefamily house yedu
House, a family house which I regard as an asset of value.
ine matitle deeds acho ari pamberi pedare iri. I think takamboma-submita pakutsvaka mapeo.
It has the title deeds and they are before the court. I believe we submitted them when we are applying for bail.
Imba iyoyo iri muzita mangu, asi muna 2018 or 2019. Actually imba iyoyo ndakaitenga muna 2008. Andichaziva mwedzi wacho. And then muna 2017 or 2018 imba iyoyo ndakaidonata ku-family trust yedu yemhuri.
The house is in my name. I believe I purchased it in 2018, but around 2017 or 2018, I donated it to our family trust.
What would you say if the state were to tell you that it is in possession of a title deed in your name?
Not in as well now, you can see in title deeds are installing.
Ichokwadi ndosaka ndati imba iyoyo iri muzita mangu.
It is true, that is why I've said it is in
Asi
my name.
kune humbowo zvekare wekuti itori neprocess yekuti yakadonetwa kudhara muna 2017 or 2008. I'm not sure about the years. Ndikuitira kuti dare isati ndanyepa, ndikuitira kuti nditaure chokwadi sematauriro amanditi nditaure zviri pachena.
But it does it is indeed that it is in my name, as I have mentioned before, but it has documents which indicate that it is in the process of having been donated 2017-18.
So andidi kuti mangwana zvozonzi imba iya yachinja zita wakanyepera dare, ndosaka ndati ndivolunteer information iyoyo zviri clear zvisere.
I would not want it to be later said that I lied to the court. That is why I volunteered this information so that it becomes clear.
But your lawyer would have told you that in mitigation, you said they have put so much assets worth so much, so that the court would be guided in arriving at the appropriate sentence.
I see. Continue to say from which was my name to Yakakosha Yaka, Shakati Shakati, Mishtarati Yakakosha Matakati Zakati, which was the reason not to by Shango.
Ipapo andidi kunyepa, ndofunga kuita rapachamba ipapo nekuti ndatotanga kunzwira pamuri and ndiri ready yangu kuzvipindura even though ndansina kuzvigadzirira.
I want to say that the lawyer made an omission on that, but I'm ready to respond to that even though I did not prepare for it.
So what is your net worth then? Because you are not being specific about fixed properties and so forth. What is your net worth?
Yes, Madam Gatina,
Patunu ngatoti maybe kuma 1 million 1.5 ikoko.
I would say about 1 million or 1.5 thereabout.
Apa ndingofungidzira sezvinhuwo mandifuta vamuchuchisa, asi chido chekuti ndikwanise kupindurai, asi ikoko ndofunga ndokona kunge ndichisvika.
I was not prepared, but I'm just responding. I want to respond to that properly.
Do you consider the offense that for which you have been convicted is a very serious offense?
Yes.
In that it was a premeditated offense.
Pakuronga apo inini ndanisina kumbobvira ndaronga mhosva sematauriro angu kumashure, asi handisi kuramba kuti ndabatwa nemhosva.
It did not premeditate to commit this offense, as I said before, but I'm not denying that I was convicted.
There was actual prejudice, according to the offense for which you have been convicted, there is an actual prejudice to the fiscus.
Mhosva makabatwa nayo hurumende yakatora skill.
Ndikuzvinzwa.
I hear you.
And that when you are given money from the treasury, effectively you are really in a position of trust. You should have performed as you were expected to do.
I hear you.
And that the money was public funds.
Yes.
And do you also accept that the actual prejudice that you say cannot be said to be law at all?
Kuramba ndingarambe zvachose, asi pamwe nechida kunzwisisa kuti prejudice yacho nema-bank guarantee, nema-bank charges, nekubhadhara ma-agents anozivikanwa nemamwe ma-related costs ari mu-bank statement yakaunzwa nestate inenge ichinzi imari yakatorwa neni here. Ipapo ndoda ku
I'm sure you have gone through the judgment that you were crying for. That such answers are found in the judgment.
maloya anga asati agara neni asi kuti vatsanangure judgment yacho kuti iri kuti.
And you also accept that there hasn't been any voluntary compensation that has been offered in this matter.
That is correct.
I therefore put it to you that the offense for which you have been convicted was committed in aggravating circumstances which outweigh the mitigatory factors.
Inini, to be honest, handifunge kudaro nekuti nyaya ye-advance payment guarantee inyaya hombe chaizvo cause yakafanana ne-insurance cover. Saka insurance cover iyaiya kana kuti advance payment guarantee, kana munhu atine shungu kana kuti aronga kuti abe akwanise kuita guarantee yakafanana neiyoyo ine mari inoenderana nemari yamukutaura.
I do not agree with that because the issue of the advance payment guarantee is a big issue. It is the same as insurance cover. So if the person has decided to still invest of funds, cannot do that with an advance payment guarantee, which is worth the amount that you are paying.
Mr. Mpofu, you are still believing that there was ever a contract arising from the tender. There was never any contract at all because it was obtained through deceit. So the issue of advance payment guarantee might not even arise because there was no contract, a proper contract from the beginning. So that issue cannot arise. You are on your own.
uzvinzwa.
One further question for the witness, my lord. No,
Are you, Mr. Koto, you are going to address the court after his testimony.
Indeed.
Very well, thank you. You can sit. I have a few questions for the witness. You said you regret the fact that Black Dick Private Limited and its directors did not do the necessary due diligence to ensure that the certificates that they were going to be used in submitting this bid were valid, and therefore failed to correct the situation. What exactly do you mean by correcting the situation?
Chananchireva ndechekuti dai ndakaziva kana kuti madirectors nemashareholders akaziva, inini Samuel Mpofu ndaigona kutanga kuti akoma ngati inoripota inyaya iyi kumapurisa.
What I meant was, if I had known, Black Dick had known that is the directors and the shareholders had known, I, as Moses Mpofu, would have suggested that we go and report the matter to the police.
Is that all? Is that all you mean?
Ndizvo zvamukureva chete.
Kubva reporting kumapurisa ndaitarisira kuti taizoengenja iyo zimra yacho, ministry yacho, NASA, tozvibudisa tega pachena kuti taona kuti zvinhu zvatatapiwa tazviona kuti hazvina kumira mushe, even imi musati mazviona. Saka tibatsireiwo tionesane kuti nyaya iyi tingaigadzirise sei, tiapply zvinhu chaizvo chaizvo.
We would also have engaged Zimra, NASA, as well as the ministry. They would have divulged it ourselves that we noticed that the documents that we received were not authentic, and they would ask them what we were then to do so that we could rectify the whole situation.
In the judgment, we found that this, not only that the tax certificates were counterfeit, we also found that in all the circumstances of the case, Black Dick Private Limited was not tax compliant. What do you say about that? In terms of rectification, what you are saying about rectification?
Papa Mutongo ndakatoka kuti tax certificates akanga si chokwadangari nani uye zvakare kuti Black Dick Private Limited yakasi kutedzera zvinodiwa.
Let me explain before you answer that question. I'm not asking you to critique the judgment. I'm just saying you have now brought this schedule of expenses because you say you now want to demonstrate on behalf of Black Dick how the money was used. And we are aware that you previously refused to speak on behalf of Black Dick. That's water under the bridge. But now that you want to correct the situation, as I'm sure that is what you want to achieve, why did you not bring anything to show that Black Dick Private Limited itself was tax compliant?
private limited same sina kubudisa zvinoratidza kuti maitedzera muchibhadhara.
Ndotenda my lord. Ipapo kutaura chokwadi handina kufunga kuti zvainge zvakakonzera, because ndaifa kuti ndenge ndakuita kunge ndikupokana neutongi hwenyu, nekuti ndakatora utongi hwenyu seutongi hwekuti ndo zviripo, even though malawyers asati kundipa interpretation yekuti zvakanyorwa paya zvinorevei chaizvo.
Truthfully speaking, I did not do that because I did not want to contest the judgment, my lord. I took it as it is, even though the lawyers have not yet explained to or interpreted what it really stated.
You still talk of a bank guarantee. Was it not cancelled?
So children is bank guarantee and now cancel
Bank guarantee rekutanga reMedbank rakakanzurwa mushure ministry payakatadza kubhadhara full payment sezvazvawirirana negarantua inova Medbank.
The first bank guarantee from Medbank was cancelled after the ministry failed to make the payments that were required by Medbank as the guarantor.
Takabva tanotora rimwe ministry ikati since guarantee rekuMedbank rakacancelewa, kuti tikubhadharei imwe payment tikuda rimwe guarantee riri valid.
We then went to acquire another one because the ministry said that this is the guarantee from Medbank had been cancelled. They wanted another one which was valid.
Ndo patakagara pasi sema.
Okay, you then supplied another.
Yes.
Sure, that's fine. Lastly, was any amount payable on the amount that you received from the ministry's tax?
Sorry, I know this.
Was any amount payable as tax from the figure that you received from the ministry? Was Black Tech supposed to be paying anything?
Taxi yaifanira kubhadhara yatakabhadhara actually IMM tax inova iyo 2% yematransactions.
IMM tax which is 2% of the transaction.
Imwe tax kuti ndijekese ndepekuti Black Tech Private Limited yanga isati ya VAT registered, yanga ichiri muprocess yeregistration yeVAT.
Loan that the tax Black Tech Private Limited was not yet VAT registered. They were in the process of being registered.
So how could they be tax compliant? I mean, how would you say they were tax compliant if they were not yet properly registered for VAT?
With all due respect, my lord, nyaya IMMT tax ainei nekuregister VAT. Ndofunga tese tikanotenga kana kuswaipa mumashops matinopinda nekuma
Okay,
kwatinotenga.
wait there. Can you translate?
With all due respect, my lord, the issue of IMMT tax has nothing to do with whether the company is registered or not.
VAT registered.
It's VAT registered or not.
Okay, I hear that. I'm talking about VAT. You said it was not yet registered. Not VAT registered. So how was it paying tax before that?
imi mataura kuti kambani yanga isina isiri VAT registered saka yaibhadhara sei tax.
Okay, ndakunzwisisai. Kana company isiri VAT registered inenge semaziviro andinozviita inenge isina obligation yekubhadhara VAT.
The company is not registered. Remind that it has no obligation to pay VAT.
I see. Thank you. So you are saying it had not paid VAT before?
Ndozva ndikutaura haisi registered for VAT and I owe Zimra any monies for VAT because haisitombori musystem yeVAT registration.
Okay, that is why I'm saying it is not registered, so it does not owe Zimra any tax because it is not in the system for VAT.
And you are saying it was not liable to pay VAT before this contract? In other words, it had not conducted any business which made it liable for that, for VAT.
Icho what? Yakaisati ya liable kuti ibhadhare ipapo pacontract yanga isina kutaura nezveVAT kana kuchaja VAT on behalf of Zimra. Saka mari yatakachaja yaiexclude VAT sekuti tati company yanga isiri VAT registered.
That is correct, my lord. It was not liable and it had not registered. So the company did not charge VAT on the amount that we charged.
And income tax on the estimated profits?
Or income tax
Iyoyo inogona kunditi netsei uipindura cause ndine uzivo hweVAT nekuti ndakambo inquire at length ndikadzidziswa, but income tax ndofunga handisi sure zvandoda kutaura.
If you are not sure, you don't need to say anything.
All right, thank you.
You can just say so. What is the response?
It might be difficult for me to answer on income tax, my lord, because on the issue of VAT, I know the parties and I was educated. They are not sure about what I want to say.
And payee on salaries?
Payee nema salaries ndoziya from the reports dzatinowana kubva kudirector responsible kuti imari dzaifamba dzichibhadhara.
I know about the payee, the salaries from the reports that we received from the director was responsible for the money that was supposed to be paid.
Yes, so the company was compliant to that extent.
Saka company yaiita zvaifanira ichiita pane izvozvo.
Semaziviro andaipiwa na responsible person, yes, ipapo pane izvozvo yaibhadhara panguva zvataita.
That is according to the information that I was receiving from the person responsible.
Yes, because if there was any proof that submitted placed before us that the company was paying all its NASA obligations, notwithstanding the prior deregistration, which is the last thing we have, and that they were up to date with the taxes, at the very least, the pay as you earn and the income tax, don't you think that would mitigate? Because what will then remain is just this question of submitting documents that were counterfeit. But you would be saying, for all intents and purposes, this was just this is mitigated by the fact that we were tax compliant anyway.
See, izvozvo rekuti kana muchiratidza kuti makanga muchibhadhara zvese zvinozikanwa nenasa zvichida kuti mabhadhara mitero yese kusanganisira mari dzekubhadhara dzinobva pamari dzekabhadhara vashandi uye zvakare nedzimwe mari dzemitero zvinotorwa sechichemo kuti manga muchibhadhara nesa siri nekuti mukinge muchinzi makabudisa gwaro risiri rechokwadi ndobva mangoti kuti chichemo chenyu chekuti isusu taiteedzera zvinodikanwa taibhadhara mitero.
In other words, you would properly be shifting blame to the consultant that you claim to have appointed.
Ndokonzwai my lord, pane iyoyo ndikuvhuma chaizvo and ndandine chikumbiro mudare rino kuti ndaigona kuti ndichiri pano pakoti ndotumira shoko kuti mangwana makuseni koendwa kuzimra konoitwa print out yekuti status yePlague Private Limited in terms of payee nezvimwe zvamataura zvakamira sei.
I hear you, my lord, and I would like to put the point that if I may be allowed to send word so that tomorrow Zimra may provide a printout of the status of Private Limited with regards to the payee as well as the other taxes that you referred to.
Thank you, accused. Oh, sorry. Any you address on anything, isn't it? Do you think you want to put questions to him in the usual way?
I know.
Okay, thank you.
Thank you, madam.
Yes, Mr. Koto?
There was also one other issue of a subpoena that we wanted to have a representative from the registrar of the Registrar General to furnish this court with a death certificate of one Kundai Mkanye.
To finish who? To finish who? To finish the court?
Yes, finish the court. A letter was filed on, was uploaded on the system requesting the registrar to help. But follow up with the registrar's officers indicated that they would prefer that there be a court order to that effect. You know. It is therefore my application before the Honorable Court that the registrar be directed to proceed accordingly and assist to have.
What information do you have on Ikunda Ipwanya?
We simply have the name and the fact that he was employed by Zimra, that is all.
So how does that help the registrar of births and deaths?
Well, from my conversations with the registrar, I was like the registrar general can actually go through the. There are so many names. Then they go through the names. There's a chance of maybe coming up identifying from the various names, assuming that he shares that name with other people. If we give them information about.
You are doing that now. You are investigating the case now. I mean, is it not something that you should have done at the beginning?
Yeah, well, at the beginning, you still recall, my lord, that during trial, it was the defense have that certificate.
Yes.
Yes. But I was liaising with my colleague, and he would insist that before he can assist, he wants the deceased's ID number. I could not come up with that ID number.
Yes, the same way. The registrar will ask her for, registrar of birth will ask for the ID number. There can be so many Kundai Bwanyas in Zimbabwe. Kundai is a very common name. Bwanya is a common surname.
Yeah,
So, but we are not trained as investigating officers. But something tells me that you are really starting from the wrong end.
yeah, well,
How do you start investigating about Kundai Bwanya in court when you know that, as you say, he worked for a company which your client contracted? Why are you not starting at the company? Why are you not starting at Zimbra? Why start in court?
well,
Is that not the logical thing to do? You did not even contract, according to you, Kundai Bwanya. You were contracted a consultant, which is a company, isn't it? That's your first port of call.
yes, it is since we proved that the consultancy is also close to this demise. So, and it was difficult for, as an individual, he has to approach.
You would have you produced any letter to the consultant company from your client?
There's no one to write that letter.
No. The letter instructing, giving instructions.
No way.
You see, a company is not. Sometimes when we get used to this concept of a company, we start believing that it's actually a person which works. Isn't it? I mean, this is a company does not have limbs, it doesn't work. It communicates through correspondence, doesn't it?
Yes.
Or through resolutions. We know that. But sometimes we elevate it to certain levels of that we think that a company might have worked on its own to instruct. There would be correspondence somewhere. Where has it been produced?
The defense intended to produce the death certificate itself. We thought that was going to be enough evidence.
How is the death certificate evidence of an instruction?
Well,
of a mandate?
No, not that it was going to be evidence of the mandate.
Yes.
But since he had mentioned in how he was engaged by the company, then the failure to call him.
What is the name of the consultants? Because if it is a company, it has perpetual existence, doesn't it? Does it die with the death of Kundai?
As I said, I don't.
So why can't you prove the existence of the consultant company through the registrar? It would survive if it is a he or she.
This consultant normally, some of them are not rated. I'm not saying it's not a rated company.
So what are you saying? Where do we start? Are you even talking about a company or an individual?
Well, he was an individual operating under a name which I am yet to get.
So there's no question of a company, isn't it? Because if it was a company, we all know that it is, in legal terms, this existence which continues even after the death of the shareholders, the directors. A company doesn't die with the death of the.
I hear what you are saying. Unfortunately, I do not have all those details because my client is not the one who dealt with him. So you also have to rely on those who dealt with him to get that information.
Yeah, you see, normally when you are asking a court to intervene, to issue a subpoena, you must say, we want this information. This is the information we have. And we are satisfied that this is the correct information. But for some reason, the registrar wants a court order so that he's protected. This is information that is normally protected, if that is what you say. Then we can compel the registrar. But what do you want me to compel him to do? Since subpoena, is it called? I can't pronounce it, but to say something like that, which just means to produce a document, isn't it?
Yes.
What document? The registrar, if assuming he was able to talk to me, would ask me which Gwanya judge. What is the ID? When was she born?
Well, I think I will use the time between now and the next court date to try and figure out if I can get.
The next court date will be sentenced.
In that event, in the interest of progress, maybe I will abandon that aspect.
Sure, I'm sure that's in the interest of your completing this case. You can see that your client wants the case completed.
Yes.
Yes. No. What are your submissions?
My Lord, in submission, I would submit that the accused is a first offender, and it has always been a tradition of these courts to try and keep first offenders out of prison wherever it is possible. I would submit that in this case, it is very possible and desirable that he be spared a jail sentence, given that the offense that he stands convicted of was actually committed by the company, and he happens to be convicted by virtue of him having been one of the directors in terms of the law. And given that scenario, it would mean that this was not an offense committed by one person, but there are several persons behind it. As per the evidence of the accused, when he was giving his testimony, the company, the material period, he had about 200 workers. And in terms of the law, each and every employee and director would be liable unless they can prove that they did not participate in the commission of the offense. In this case, it is common cause that the other people who are not before the court and who have not been convicted, it is not because they proved themselves that they did not participate in the offense, but due to the fact that the state decided not to proceed against them for whatever reason for which the state is entitled to. But at the end of the day, my Lord, justice is treating like alike. The fact that there are other people who are walking scot-free when they were in the same circumstances with the accused person shows a miscarriage of justice if accused person was to be incarcerated for the offenses, for this offense which in terms of the law was committed by many people. Then in terms of the sentencing guidelines, my Lord, it is a requirement that in coming up with the appropriate sentence, this court should try to by all means to impose a sentence which is proportionate to the offense and in line with the general sentences that are imposed in offenses of this nature. My Lord, I would like to refer you to the case of S versus Chimombe. It's 1992, volume 2, Zimbabwe Law Report, page 153.
What is the citation again?
S versus Chimombe. Yes, a criminal review by Smith J.
What is the citation?
It's S versus Chimombe, 1992, volume 2, Zimbabwe Law Report, 153. A judgment, review judgment by Smith J. My Lord, offenses of this nature that accused person stands convicted of is one of faking qualifications, because Black Deck is said to have faked the qualification by using particulars of another company to represent that it was test compliant. So it falls in the same category as offenses of people who use false qualifications to obtain a contract for a job. In this case, the convicted person yet used particulars of his elder brother, that is his birth certificate, national ID,
And you use that to get a contract?
Yes,
A government contract?
yes, and and he enrolled he was employed as a teacher and the offense was discovered after 3 months because of his lack of qualifications, obviously it sold him out. So he was convicted, by which time he had already earned an amount of $2,031. The sentencing magistrate yet imposed an effective 3-month sentence. After the whole sentence, in fact, was 12 months, 9 months suspended on good behavior, then 3 months suspended on condition he restituted of the whole amount that he had received as a salary, that was $2,031. The High Court indicated that this was a serious misdirection because the offense that had been committed by the offender was one of faking qualifications. Now, it was not in accordance with the Administration of Justice that he be ordered to pay restitution, because the money that he got was a salary that he had worked for. So the line of reasoning here by Smith J. was that there must be a distinction between what the offender did, like in this case, using fraudulent documents. But then what is earned after the contract cannot be treated as prejudice. So because of that, the sentence was quashed, and in its place, a fine was imposed. In doing so, the court also was proceeding in terms of the reasoning in it was the reasoning in S versus Casibon. S versus Casibon, High Court Harare, 256 of 84. In that case, the convicted person yet used a certificate awarded to a sister to obtain enrollment as a medical assistant, and had worked for 19 months, earning $2,242. Again, it was held that the issue of fraud was supposed to be treated separately from what was paid. And the same was said in the case of S versus Chatumbura, again, High Court Harare 119 of 85. So what this line of cases prove, my lord, is that in cases of faking qualifications, our courts have always maintained that it is improper to impose an effective prison sentence. The most recent case is one of State versus Kalenga. It's High Court Harare 416 of 18. In that case, the High Court judge learned from reading a newspaper that a person who had forged qualifications to enroll as a nurse had been jailed for an effective 10 months in prison. That was considered to be a very shocking sentence, to the extent that despite that, the accused herself had not approached the High Court for justice. The High Court itself decided to approach here in terms of the law and find the record to correct that anomaly, because the sentence of 10 months was very shocking, and it was set aside, and in its place, the accused was sentenced to $200 or in default payment of, in default 1 month in prison. It was held that an effective imprisonment for the offense in question is rather shocking and out of sync with sentences in similar cases. And the court emphasized that the High Court has on numerous occasions pointed out that effective imprisonment must only be used as a last resort. So I will urge the Honorable Court to adopt the same line of reasoning and adopt the same sentencing regime. I also am aware that my colleague was so much interested with the issue in the interest of restitution. Having said, my Lord, having quoted that those cases, my Lord, it is my submission that the fact that Black Private Limited submitted, or has been found to have submitted fake tax clearance certificate and NASA compliance certificate, does not necessarily mean that the prejudice suffered was the amount of the contract, which is the 7.7 million. If we adopt this, the reasoning adopted in the cases that I have just read out to the court, those are distinct transactions. It could be very well that Black was going to perform well after getting the money. Just like in these cases, the court was emphasizing that if he teaches and then whatever he earns is his money, you should not consider that as prejudice, and you should never order restitution. So, if Black failed to perform in terms of the contract, then the question should be, why did it fail? What caused the failure? The court has to investigate that. It is not automatic that failure is because it had obtained that contract by fraudulent means.
In other words, the words that you are putting into my mouth, that I must write in my reasons for sentence, that it is okay to rig in government tenders as long as you eventually perform.
My Lord, I am not saying that. I'm saying what the law from the previous cases is saying. Because
I want to capture
yes,
your submissions if I accept them,
yeah,
and make them part of the reasons for sentence,
yeah,
for not sentencing your client to imprisonment.
yeah.
We are saying the attitude of the court is that it doesn't really matter. Even if you're not qualified for government contract, you can rig your way. And, you know, that doesn't matter at all. We're just concerned with whether or not you eventually perform. Is that the correct approach?
No, it is not the. It is not like we are saying it doesn't matter that you have rigged. That is why in all those cases, the accused person or the offender was sentenced. It's not like the High Court just said, okay, it's okay, you can go.
Yes.
The person was sentenced, but it was a question of what is the appropriate sentence. What our courts have always tried to guard against is to impose an effective sentence.
So in those cases that you have cited, the people concerned did not have certificates, isn't it?
Yes, they were using other people's certificates.
So you are saying they are on all fours with this case because Black Private Limited was not tax compliant.
Indeed, because according to the judgment, my Lord, they faked compliance, that is faking qualification when indeed it was not qualified. Because if it was found that
No, that's all. I wanted just to be sure that you are saying the facts are on all fours.
Yes.
Because in those particular cases,
yeah,
whoever were employed, the accused person, the offenders, right,
the offenders, yes,
were not qualified.
Yes, we are not qualified.
And you are saying we must approach this sentencing from the premises that it is admitted that Black Tech Private Limited was not qualified.
Yes, but then it faked qualification and obtained a contract just like those nurses, those teachers were contracted with the government when they were not entitled to those contracts and they earned money. Now, I also refer the court to Section 11 of the Criminal Law Codification Reform Act to try and assist in the relationship between the offense that was committed and the money that was paid. It says a person shall not be held criminal liable for a consequence unless the person's conduct caused or substantially contributed to its occurrence. A person's conduct shall be deemed to have caused or substantially contributed to a consequence for the purpose of subsection 1 if the conduct is the factual cause of the consequence, that is, but for the conduct, the consequence would not have occurred. And is the legal cause of the consequence, that is, the consequence was reasonably foreseeable consequence of his or her conduct, or was brought about by a new cause supervening after his or her conduct, which cause was itself a reasonably foreseeable consequence of his or her conduct. So what I implore the court is to ask itself that, was it reasonably foreseeable at the time of submitting the tender documents? That was sometime in November 2021 or thereabout, that if Black Tech manages to obtain this contract on the basis of fraudulent tax and NASA...
You want to continue? You want to continue with that? Do you
yes, I was going.
Yes, that's why I just thought I should stop you because I'm sure you are getting lost, terribly lost.
No, I'm actually addressing it on the part of the failure to pay to bring the goods.
So
to say if I submit this fake tax certificate, the ministry was going to fail to advance money in April of the next year as per contract. So those are two distinct transactions. So we are saying the failure to provide goods was not in any way linked to the offense that was committed by Black Tech Private Limited of submitting or obtaining the contract on the basis of fake papers. The two transactions must be kept separate.
if you feed me with poison, I will produce poison.
Yes, yes. I'm trying to
You understand?
Yes.
I'm sure your friend at the bar has tried to correct you.
Yes.
Don't. This is at the High Court level.
Yes.
We don't want to distort the law.
Yes.
You see, I think what you are telling us is something that I shouldn't even be writing.
That is my submission. I think I will obviously.
Look, if somebody look at the definition of fraud. It just means that you make a misrepresentation with intent that somebody should act on it to their prejudice. They've been convicted of that offense. Don't go back to those elements of the crime. We are past that.
No, I'm not in the element of crime. Yes. I'm saying the offense by Black Tech starts and ends with making the ministry act on the basis of false documents to award a tender. But then when it comes to the issue of failure to deliver goods in terms of the resulting contract, it is now something that is divorced.
Have you read the code in full, the criminal law code in full?
Yes.
Doesn't it say that it's not even necessary to identify the person who was prejudiced for a conviction to sue?
For a conviction.
In other words, all these other things you are mentioning are not really critical. This was an open tender, isn't it?
Yes.
If Black Tech Private Limited had been disqualified, doesn't it mean that other companies would have tried?
Well, I will go back, my lord, to the issue of the teachers and the nurses. Yet they not applied, realizing that they are not qualified. It means someone else with the qualification would have obtained the teaching
We
post.
don't
on
want
this.
academic arguments. Just make useful mitigation on behalf of your client. That's
Yes.
that's something for a thesis.
My Lord, I'm saying that, my Lord, as I had indicated that this case is on all fours, and in your judgment you even mentioned that this was a case of stealing identity. So it is on all fours with those cases, previous cases, where one would use particulars of a sister, one would use particulars of a brother. And the court has always insisted that, notwithstanding that, what you earned is not part of the crime. So that's where I'm going, my Lord. What was earned is not part of the
Did you
crime.
read the judgment properly?
Yes, I read it. I read it. Yes. Then, I also want to refer the Honorable Court to the provisions of section 366 of the Criminal Procedure and Evidence Act, which says that in his cases where award or order not to be made.
366.
Yes,
What part of the criminal
it's part
procedure and evidence?
part 19.
What does part 19 deal with?
It's compensation and restitution.
So why are you going there?
Well, I'm now addressing the issue of restitution. As I said that my colleague tied on the issue of restitution.
The prosecutor did not apply for any compensation. Did he?
In his cross-examination of my client, he was querying why there was no
What's part 18 about?
part 19.
That's part 19, compensation and what? Restitution.
Compensation and restitution.
Yes.
Yes.
Then part 18. Of the CP&D Act.
It's on punishment.
Punishments. So we are at the stage of punishment.
Yes.
We are in part 18. We are not in part 19.
Well, I will address that one, the prosecutor.
You probably didn't even appreciate the gist.
Yeah.
In part 18, a court punishing the accused may suspend part of the sentence on condition of restitution.
Yes.
That is what the prosecutor was talking about.
Yes.
He did not make an application for restitution in terms of part 19. The order for restitution in part 19 is in fact a civil award, a civil order which is registrable somewhere there and executable. That's not what he has asked it for.
Well, yes.
He was actually drawing your attention to something that you had omitted to do. That in mitigation, you should, say to the court, if you are going to sentence our client to imprisonment, please suspend part of it on condition of restitution. That is, somehow, I felt he was giving you a hint.
Yes, my Lord.
But you are lost. You are now in part 19.
No, my Lord. My intention was to try to address why that offer was not made.
Offer wasn't what?
For restitution and mitigation.
No. The prosecutor is trying to say to you,
Yes.
remind you that your client can benefit from suspension of the sentence which may be imposed by this court if he offers restitution.
Yes.
You see?
Yes.
And he's saying, because that is usually a sign of contrition.
Yes.
If the court sentences me to a year, can 6 months be suspended on condition that I pay the money and so that I don't go to prison? That is what the prosecutor is talking. He's not talking about, he's not making an application for an award.
Well, I'm speaking from a position of having read the filed submission. That's why I had gone to that. Because I know in the written submissions,
He made an application for an award.
Yes, that's my understanding.
Sorry, maybe I wait a second. Did you? Maybe I overlooked that. could do.
No, Your Worship. No, my lord.
Is there an application in terms of look at part 19? Wait, let me just get there. I thought that was now tried, almost. Just wait a second. Yes, have you gone through part 19?
Part 19.
Yes. Do you see an application by the prosecutor in terms of part 19 anyway?
Well, in his conclusion, my lord, where he proposes that 5 years be suspended on condition they pay restitution the sum of.
Yes, that's punishment.
Yes.
It's not in terms of part 19. If you look, you said section, you see, you see what you must do, Mr. Koto. You must just refresh your memory on the act before you make submissions, from the CAF. You must, when the prosecutor said the portion must be, you must then look for the law which empowers to suspend sentences and find it and find where it's located.
Yes.
Yes.
So,
Those are the powers for a court to suspend a sentence on condition of restitution.
yes, my lord.
Yes.
The prosecutor was saying that the fact that he has omitted to offer restitution, therefore it means he is not remorseful.
Yes.
Yes. So justifying why he did not offer that.
So why were you taking us to part 19?
Yes.
When suspension of sentences in terms of part 18, just means you didn't read the law.
No, my lord.
Not at this level, Mr. Koto.
My lord, I referred you there because that section empowers.
Okay, you can proceed.
Yes, that section, my lord, actually says the court must not even order compensation, restitution.
Yeah, you were reading the wrong law, Mr. Koto. Why don't you just admit that? I'm simply saying if you mislead the judge, we will distort the law. Isn't it? This is a very high level. You're supposed to come to court, look at the provisions which govern suspension of sentences and make the correct submissions. This is the High Court. You can't just be coming to court to make submissions like that.
My lord, well, I don't know if
Because magistrates will start following that. You see, that's the danger.
I move on, my lord. I move on. In terms of the sentencing guidelines, my lord, once the court finds that the there are highly aggravating circumstances in the manner in which the offense was committed, then the sentence, the presumptive sentence is 20 years imprisonment. My Lord, I'm
Sorry,
saying,
you're saying? So say that again, take that again.
where the court makes the finding that they are highly aggravating circumstances.
Where are you reading from?
It's from the table.
Okay.
Yes, from the table. The presumptive sentence would be 20 years imprisonment. But in, where there are no such highly aggravating circumstances, the sentence would be in the region of 6 months imprisonment.
Okay.
Now, in this case, my
Is
Lord,
this court bound by the sentencing guidelines?
it's not bound, my Lord. But
It is
that's
not.
the starting point. It's just
Is
the
that,
guideline.
is that
Yes.
what they say?
Yes.
What do the sentencing guidelines say?
They say that the court is at large to depart as long as it gives reasons.
Do you have the sentencing guidelines?
Yes.
Here, you have them.
Yes.
Okay. What is the definition of presumptive penalty?
It is sort of an...
Read it.
Presumptive penalty means a penalty expressed as a specific amount of a fine or a specific period of imprisonment, or both, that is midway between an augmented penalty, which may be imposed in aggravating circumstances, and a diminished penalty, which may be imposed in mitigating circumstances.
And below that, the next subsection. Which section are you reading?
Our under definitions.
Oh. Okay. Let me do the work for you. So it is a sentence which is midway
Yes, midway.
between the augmented penalty, which may be imposed in aggravating circumstances,
Yeah.
and diminished penalty, which may be imposed. So it's either, what does that mean?
It can be. On the upper side.
How do you interpret that to a layman? What is being said there?
Well, what is being said is that the court might go up or down depending on its findings on aggravating or mitigating circumstances.
Section 5. Subsection 2.
Where these guidelines have provided for a presumptive penalty, the court shall pay due regard to the applicable sentencing guidelines when sentencing offenders. Subsection 2, where a sentencing court departs from a prescribed presumptive penalty as provided for in these guidelines, it shall give reasons for that departure.
So where a sentencing court departs from a prescribed presumptive penalty as provided for in these guidelines, it shall give reasons for
Yes.
that. What is the what do you say about this case? Was it committed in aggravating circumstances, or it was committed in what in circumstances that call for a diminished penalty? There are two,
Yes.
isn't it? It is either the penalty prescribed for an offense committed in aggravating circumstances,
Yes.
or that sentence which a diminished penalty because it is committed in mitigating circumstances. There are always two presumptive sentences provided for, isn't it?
Yes.
One for that offense committed in mitigating circumstances,
Yes.
and one prescribed for those committed in aggravated circumstances. You agree?
Yes.
So the law does not provide only one presumptive penalty. It provides how many?
Two.
Two.
Yes.
So I want you to assist me in determining which of the two should I start from.
Yes.
Which of the two should? What is the prescribed sentence for fraud committed in aggravating circumstances?
That's what I said. It's 20 years imprisonment
And what is the penalty provided for, presumptive penalty for the diminished penalty for fraud committed in mitigating circumstances?
6 months.
Yes.
Yes.
So now I want you to assist us to consider whether in which category is this case. Was it offense committed in mitigating? Or?
If the court may bear with us, just give me an interruption. The second accused reply gave very short, like 1 minute break to get to answer to the calls of nature.
Very well. State. The court will adjourn for 5 minutes.
Social media, dengar kutuka. Dengar kutuka. Tune. Tune.
pakashata ikada uzosimcontact uzokuivo careful.
That's why you should be listening. I will never perform.
Ayo, kuti.
This was my lawyer that was sent under trial.
Already, itazvigadzira kusu.
Kwadi kumbokuda. Ndoita mitigation yavengonoziva. Ikoni nomau yatajaira.
Halo.
adopting the evidence that was given by the accused person, that what led to the failure of Blackdeck to deliver the goods as the contract was not because of Blackdeck itself, but it was because of the ministry's breach and the resultant, the eventual cancellation of the contract. So
No,
in this
that's
case-
not. Is that what you consider in deciding which way to start from?
we are talking of prejudice. So,
No, no. I'm saying there are two presumptive penalties.
yes,
You have to decide which. What are the two presumptive penalties? One for
20
an
years.
offense, fraud committed in aggravating circumstances is 20 years.
20 years.
One for
For
an offense committed in mitigating circumstances,
is 6 now.
6 months or what? It's just 6 months.
Well, yes, that's 6 months.
Oh, wait, I want to get there. Is it not level 14? What? No. Where is that? Level 4. What? Oh, 6 months imprisonment.
Yes. Because
So,
level
so
four-
there's no option of a fine.
No, since even the highest, the 35-year imprisonment provides for the highest fine of.
No. I understand.
Yes.
So in mitigating circumstances, there's no option of a fine.
No, well, then we come to another thing that for any, the offense itself provides for a fine as an alternative. Yes.
Yeah, I'm saying the presumptive penalty is not a fine. It is
Yes.
a sentence of imprisonment.
Yes, according to this table. But
Yes.
obviously the court is not bound to impose.
I
a
know,
fine.
we can go down and eventually impose a
Can
fine.
impose a fine.
But in
commit
both
service,
cases,
commit
in
service.
both cases, the presumptive penalty is imprisonment.
Yes,
Okay.
yes.
So why do you say we must start from that diminished penalty?
Right.
Looking at the guidelines themselves,
Yes.
why do you say that?
Well, because we are saying potential or actual prejudice was low or insignificant.
Mm-hmm.
Yes. So my submission,
Yes, and then?
well, there is also where there has been voluntarily compensated the victim in full.
Yes.
Yes.
So now let us interrogate that.
Yeah.
Is your client voluntarily compensated?
It is not voluntarily compensated. my
So
lord.
that mitigating circumstance is just not there.
Yes.
Okay. What was the potential prejudice?
It's a good administration, my lord. That the ministry was made to act on the basis of fraudulent papers. So there was prejudice as to good administration. And because of that, there can be no issue of
So there's no
compensation.
potential prejudice in terms of figures.
No,
What
there-
was the amount of the contract?
No, that's why, my lord, I was saying from my initial submission that the issue of the contract and the issue of the offense must be separated according to the cases that I referred you to. So
The issue of
there's no,
the issue of the contract.
yes,
Must what?
the issue of
Okay,
the
what
offense-
is the fraud that your client was found?
The fraud is that Blackdeck obtained an award on the basis of a fraudulent tax clearance certificate and a fraudulent NASA
Yes.
compliance certificate.
What was the value of the award?
The value of the award,
Yes, that was granted to it. What was the value of the tender?
no, not the tender, but the contract. We only get value once we
Okay,
get into
yes,
the
yes,
contract.
yes.
Yes,
Okay.
the value of the
The
contract.
contract that was awarded to it.
Yes.
Yes. What was it?
It was 87 million. Yes.
So that is the amount, that is the value of the contract that it received, that was awarded to Blackdeck as a result of the misrepresentation. Is that so?
As a result of the vision.
Yes.
From the cases that I once outlined to the court, my lord, I'm saying that there must be a distinction between the offense of fraud in supplying fraudulent tax clearance certificate and what was then done in terms of a contract. The same way the court have said, once you fake qualifications and obtain a job, the prejudice cannot be judged by looking at what was then paid. That is wrong. That is the wrong premises that the High Court was correcting in all the cases that I read to the court, my lord. To say there is no relationship.
Okay. The misrepresentation, the falsified certificates were submitted in order for the bidder to qualify for a tender.
Yes.
What was the value of the tender?
The value of the tender, I have not seen any amount indicated on the tender document, but the amount only starts...
Do you not know what the bidder got eventually?
Well, the contract,
Yes.
when the contract was
You got
signed...
a contract?
Yes.
What was the value of that contract?
It was 87 million, my lord.
Yes. Is that not potential prejudice?
No, according to the cases that I have given. I know that you are free to give it your own interpretation. But in light of all the cases that I have highlighted, my lord, the emphasis of the High Court was that it is wrong to refer to what was paid as the prejudice.
No. They are talking about actual. I'm talking about potential.
But
Fair enough, in terms of a teacher employed, you can't really quantify it because it's for as long as the teacher remains employed, is receiving salaries.
yes,
And this prejudice is something else. It's not about the rationale behind those judgments, if you read them correctly, is that this teacher is providing a service and is being paid for it.
yes,
You see, the prejudice is just the good administration of whatever the ministry administers. It needs qualified teachers to teach people and so on. You see, so that's. But is it the same here in this case? What did the perpetrator, the offender, intend to achieve by submitting falsified documents?
a contract,
A contract which is worth how much?
87 million.
Yes. So you are saying it doesn't matter if, eventually if he performs, then there will be no actual prejudice. But what was the potential prejudice in the event that they did not perform? There's a distinction between potential and actual.
Yes,
Yes. What would be the potential
it
prejudice?
would be 87 million.
Yes. Is that law?
No, if we look at it from that angle, it is not law.
Can we look at it from another angle?
Yes, my lord, from the position that
It was not potential prejudice.
there was only prejudice to good administration by being made to act on the basis of fraudulent documents.
Okay.
Yes, so that will be...
Okay, so then are there no aggravating circumstances?
my lord, given the history of this matter, my lord, where we find that Blackdeck was actually writing, complaining that, can you please
No,
perform so that
I'm
we
still
deliver?
at the stage of determining where to start from.
Yes.
It says if a offense is committed in aggravating circumstances, you start from 20 years.
Yes.
Then the aggravating circumstances are listed.
Yes.
What are they?
That items, funds or property involved were of a considerable value. Funds or items involved not recovered. Offender was in a position of trust. Offender was the holder of a public office. Offense involving loss of public funds.
Mm-hmm. And you don't find any?
My lord, that's why I was trying to make a distinction, my lord, to say the offense of submitting fraudulent document, my lord, is not connected to the resultant loss. Actually, in terms of...
so this fraud did not involve public funds?
Yes, to the extent, my lord, that I quoted section 11, my lord. What I'm trying to say is that there was now an intervening cause, the so-called novus actors intervening.
So what did the offender intend to access?
A contract, my lord. An award of
A contract.
that is an award of the tender.
That's all.
An award, then once each yet obtained an award, it would then perform in terms of that contract and earn a profit.
From what?
from the contract. Once the contract
Yes,
has been
from
entered
what?
into.
Profit is, what is
From
profit?
the contract, from the performance of the contract.
Yes,
my lord.
profit is what? What is profit?
It's income.
Not, so those are not funds. It's not monetary.
My lord, the purpose why I read section 11, my lord, to say that there must be a causal link. My argument is that this is a case of a novice act as intervenient. There was an intervening cause which is quite distinct and disconnected from the initial act of submitting fraudulent documents. So the contract, whatever was paid,
But you have
should
been
not-
telling us all time that the government was supposed to pay 30%. 30% of what?
30% of the contract price, my lord.
Yes, and what is that? Not public funds.
It's public funds.
So,
Yes, I'm saying, my lord,
So-
there must be.
so why are you saying public funds are not involved in this case?
No, my lord, what I am saying is public funds were paid in pursuit of a contract.
Yes.
Then the contract, then the court now must look into whether Blackjack performed. If it did not perform, what was the reason? Was it the intention at the time of submitting the fraudulent documents that it intended to prejudice the state of the amount by which it failed to deliver the goods? That has always been my point, my lord.
Anything else?
That would be all, my lord.
Yes, the State Council spoke about contrition. Contrition is shown in many ways. By paying, restituting, even if under protest, it doesn't matter. You can restitute if you want a lighter sentence. In what other way, in terms of case law, how do you show contrition?
Restitution, I'm not aware of any.
Those cases which you referred us to, isn't it that the accused persons pleaded guilty,
Yes, they pleaded guilty
which was a sign
of conviction. Well, but my lord, yes, a plea of guilt can be a sign of conviction, but
of? No, I'm just asking you because you have said
yes.
in your submissions, Blackjack Private Limited faked qualifications.
Yes.
So it knew all along that it faked qualifications. What was the purpose of this trial?
No, my lord, as he was saying during mitigation, my lord, that and he was also saying that during trial, that for all along, he thought that those seized with administration, financial administration, were doing their jobs properly. It only dawned on him that there was a problem when he was arrested. And he actually saw the...
For you,
Yes.
and was it something that you couldn't verify easily and obviate a trial? Was it really necessary to go all the way 1 year, 2 months, denying, insisting that Blackjack is tax compliant, when you knew, or at the very least, you had not even looked into it? Now you know that clearly it's beyond redemption, and now you say, oh, indeed, we're not tax compliant. We faked certificates. Is that a sign of contrition? Is that supported by the cases that you have cited? Because I know all those cases dealt with teachers who, when caught, say, well, we have caught us. We are sorry. That's contrition, isn't it?
Yes, my lord.
And now we have gone 1.5 years doing this trial. And you knew that Blackjack faked tax clearance certificates. What was it really necessary? I'm sure you read this judgment.
Yes, my lord.
And we said this is a judgment which should have proceeded on the basis of a statement of agreed facts. But at least with respect to your client, I must be very clear about that. I don't refer to the second. Because now everything is admitted. Isn't it? That effect, your client is the director of Blackjack Private Limited. He still is now. Isn't it? He was saying, I'm no longer. Now he has said he is. But he knew that was this trial necessary? I want you to be honest about that. Is that any sign of contrition?
My Lord, let me start by saying pleading guilty is not always a sign of contrition. There are situations when there is no other way out. For instance, where one knows that he has never gone even up to grade 7, but he produces an A-level certificate belonging to a brother or sister.
Yes.
In that case, it cannot be said that by pleading guilty it's a sign of contrition. No, there's just no way to run.
No, it is. You can try.
Well,
You know, people can always try.
yes.
Courts always reward people who come to court and say, you have caught me,
Yes.
isn't it? Now, let me confess, I'm sorry.
Yes.
Courts always reward that.
Yes. My Lord.
You can even be cautioned and discharged by courts.
Yes.
You know that?
Yes, I understand.
Yes.
Yes.
But now a situation where you take 1 year, 2 months denying something that is a fact, is that contrition?
My Lord, with all due respect, we are saying that Black Tech faked the documents because that is the judgment, and there's no way we can make any submission that tends to contradict
Oh,
the
I
judgment.
see. Is that what you mean?
Yes. Yes. Not that we are saying that
I won't
we
assist
have
you any
always.
further.
Yes.
I won't assist you any further. Anything else?
That's all.
How long do you think you will be, Mr. Matuku?
We will be very short. We will share the time. My learned friend will deal with very briefly on the personal circumstances of the
Okay, you are going to just make submissions.
We'll make submissions.
Thank you. You can proceed.
I will then come in on the legal aspects.
Thank you.
Thank you, my Lord. We'll endeavor to be brief, my Lord. We are all serious that this matter should be at least be finalized today if it's possible. My Lord, the starting point in mitigation would be the sentencing guidelines, which in this case are provided for. My Lord, there's no doubt that the second accused stands convicted of a serious offense. There's no doubt that the presumptive penalty as provided for in the sentencing guidelines is 20 years imprisonment. However, my Lord, I would implore this court to then consider Section 5 of the sentencing guidelines. What that section provides for is that the sentencing guidelines are binding on the court. However, Section B of the same sentencing guidelines implores the court where there are deserving circumstances to depart from the presumptive penalty. In other words, my Lord, the sentencing guidelines do not take away the discretion of the court in coming up with an appropriate sentence where the court finds that indeed the case deserves so. My Lord, I'll cite the case of State versus Kufandada, which is Harare High Court. Judgment 233, 2024. It's a judgment by 2 judges of the High Court. One by Muremba J and Mtevezi J. That judgment interprets Section 5 of the guidelines and goes on in detail to promulgate or to state circumstances under which a court can depart from the presumptive penalty that is provided for in the sentencing guidelines. There's also the case of State versus Macheka, Harare High Court.
Which country?
Sorry, my lord, if I'm being too fast, my lord.
No, that's fine. HH?
HH 326 of 24. It also provides for the same concept or the same ratio dissident as for the other case that I've cited, my lord. My lord, then the next point is that the court must then look at section 6 of the sentencing guidelines. And there is a recent case by your brother Judge Chikowero J, which I consider that perhaps it is the leading case right now as we stand here in as far as sentencing of fraud matters are concerned. It is HH 409 of 25. What that case says...
What is the case name?
State versus Mupamaonde and others. HH 409 stroke 25. What that case says, my lord, is that in coming up with the appropriate sentence, the court is employed to look at section 6 of the sentencing guidelines and make a finding on where to start. When it comes to the presumptive penalty. The court must consider the aggravating circumstances and the mitigating circumstances of each case. And then the court must then consider whether or not the aggravating circumstances far outweighs the mitigating factors in coming up with the appropriate sentence. And my lord, our submissions are that in as far as the commissioning of this offense is concerned, there are very much mitigating factors which far outweigh aggravating factors when it comes to what the court must consider as the appropriate sentence. In doing so, my lord, we will start by citing section 9, my lord, of the sentencing guidelines. Section 9 thereof does list factors which are mitigating. And it is our submission that those factors are very much alive and present when it comes to this case. The first factor, my lord, that is listed is that whether or not the accused is a first offender. We submit that the second accused is a first offender, and that this should work in favor when the court is assessing the appropriate sentence. The second factor that I want to implore this court on is to do with contrition. Our submissions are that the second accused is very much contrite, and to show or demonstrate this, the second accused is willing, if the court so orders, to restitute. The other factor that is listed under Section 9 is the court must assess whether there is any risk of reoffending. My Lord, our submissions are that there is no possibility that the second accused may in future reoffend for the same offense or any offense involving dishonesty. This has been his first brush with the law, and that he has learned a lesson, and he would want to bring the court in its confidence that he will not repeat the same offense in future. The other factor that is listed there, my Lord, is that the court must consider pre-trial incarceration. My Lord, it is clear that the second accused and even the first accused have been in custody for a period of close to 18 months now. They were incarcerated sometime in June 2024. They have been in custody ever since, and our submissions are that this has been a lengthy period of pre-trial detention. My Lord, what is important is that Section 9 of the sentencing guidelines does not end there. It then implores the court to look at other mitigating factors which may be outside of Section 9. And our submissions are that there exist other mitigating factors which this court must consider when it comes to the appropriate sentence. Before I go on to those personal circumstances which I think are mitigating with respect to the second accused, I would like to also just point out to the court that under Section 12 of the same sentencing guidelines, the court is implored to look at certain factors when it comes to assessing the appropriate sentence, one of which is the background of the offender. My Lord, the second accused is aged 44. He is married. He is a traditional African man who is married to 3 wives. He has 15 children, all of who are minors. None of them is above the age of 18. The second accused was born in Chinoi, in Murombedzi. He grew up in a rural homestead, went to school, both his primary education as well as secondary education at rural schools. He finished his O-level and he did not advance with his education. He then joined politics from a very young age. He has always been a member of the ruling party. He then ventured into business. His is a locus classicus case of a rags to riches story. He propelled himself to be economically empowered through genuine business ventures and through hard work to be where he is. So the submission that we make is that if the court considers his background, he really is a person who the court must look as an unsophisticated person, one who would not really sit down to premeditate to commit offenses of such a serious nature. The second accused, as I have said, my lord, is a businessman and a farmer. He used to earn on average around 15,000 to 20,000 a month from farming and his other various business ventures. He has some assets of value. He owns a property, an immovable asset, of which we've previously submitted some title deeds to this honorable court. The property is a house located in Borodale. It is worth 800,000 US dollars. He also has another property in Chinoy, which is worth around 120,000 US dollars.
You said the property in Borodale is worth what?
800,000, my lord. 800,000 US dollars. He has a property in Chinoy. The property is worth US 120,000. The second accused also owns various cars with a combined value of around 200,000 US dollars. These are the personal assets that are in his name. My lord, the other personal circumstances that we find mitigating when it comes to the second accused is that he has a chronic illness. He suffers from diabetes as well as BP. This requires for him to be on constant medication. He used, before his incarceration, he would visit South Africa at least twice a year in order to get treated for this chronic illness. And the unfortunate reality is that incarceration will obviously affect his mental, rather his health would be impacted negatively. The other submission that we would like to make to the court is that throughout the judgment of the court, or throughout the verdict and the judgment, while he accepts that he has been convicted of this serious offense and he is willing to take the responsibility that comes with that conviction, the court, one can discern from the reasoning of the court that the participation of the second accused was somehow minimum. If one looks at the judgment itself, it is quite clear that the second accused participation was way after the bid or the offending bid had been submitted. He thereafter then attended several meetings. So clearly, my lord, one can argue that the participation of the accused, the second accused, he really played a minor role in the commissioning of this offense. My lord, there's another factor that I would like to implore this court to consider. When investigations started, the second accused, or rather both accused persons, were outside of the country. They were in China at the time. They were, rather, a press conference was issued by the Zimbabwe Anti-Corruption that they were wanted back in Zimbabwe. They traveled back on their own. At some point, they were interviewed by members of the Zimbabwe Anti-Corruption, wherein these allegations were favored against them. They were excused, they went back home. They were then re-invited, they came. This gives an impression or shows that both these accused persons cooperated with the law enforcement agencies. They assisted the police with the necessary questions, or the necessary interviews. They did not resist. They did not flee, even if they had that opportunity to do so. Even if they now stand convicted, they should clearly benefit from that conduct. My lord, our submissions are that, yes, in aggravation, they stand convicted of a serious offense. Yes, the offense involves public funds. Yes, indeed, there has not been restitution as of now. But what also works in their favor, my lord, is that none of them is a public official. None of them was in a position of trust. My lord, what I would then implore the court would be to consider the following two cases. That of State versus Madembo and others, 2003, Volume 1, Zimbabwe Law Reports, at page 137, as well as State versus Mahove and others, 2009, Volume 2, Zimbabwe Law Reports, at page 19. What does...
Sorry, can I have the citation of the Mahove case?
State versus Mahove and others, 2009, Volume 2, Zimbabwe Law Reports, at page 19. It's a Supreme Court decision. My lord, what those two cases implore the court is that when a court makes a positive finding that there are mitigating factors in a case, this must be reflected in the court's reasons for sentence. There must be a discount that is reflected. So our submission are that even if the presumptive penalty is 20 years, there are many factors that are mitigating, and that this must diminish the sentence from the 20 years or the presumptive sentence of 20 years, and that this must be reflected in the court's own judgment, where a discount of that sentence is then clearly elaborated from the sentence. My Lord, unless you want me to address on any other issue, those will be our submissions. My colleague will definitely deal with the other legal issues.
The appropriate sentence is a legal issue, isn't it? So we'll deal with that with
Thank you,
Mr.
Madam.
Matuka.
Thank you. My Lord and learned assessors will be very brief because my learned friend has covered almost everything. I just want to deal with 2 points. The first one is to give a legal basis for the submission that has been made that the second accused played a very minor role. That is our submission in the commission of the offense. The legal basis is in terms of the sentencing guidelines, section 9. Sorry about it. I'm not sure whether you captured it.
You may have to start.
I have to start, yes. My little friend has covered almost all the submissions that we wanted to make. But I have to add 2 things. And the first one is to give a legal basis for the submission that the second accused played a minor role. It is section 9, paragraph K of the sentencing guidelines. This court ought to take into account the degree of participation in the commission of the offense. The judgment is very clear in that regard, and I would say that when the court is doing that in terms of its own written judgment, it would have to start on page 40 of the written judgment, and then it will have to go to page 51 up to 53. Page 40 and then 51 to 53. It's clear there. We may be wrong in our interpretation of the sections of the judgment, but the court makes it clear that he's being convicted by associating himself with an offense or with conduct that had already been committed. And in this case, it says that he also would have participated via Miltech. This is said there. And then he associated himself with what Blake Deck had done. And then, of course, with his association, the first accused. Our submission is that the court has not found, for conviction purposes, that he was a principal perpetrator. So on page 40 of the judgment, where this court cited the provisions of section 196A of the criminal law codification, which says liability of co-perpetrators. The attention I wish to draw the court to is the fact that that section actually has what it calls an actual perpetrator and then a co-perpetrator. Sometimes in some cases you cannot tell who is the actual perpetrator. And then there are cases where you say this is an actual perpetrator and then you are a co-perpetrator. In this case, this court has found that the second accused was not an actual perpetrator. He was a co-perpetrator in the sense that the judgment itself identifies the first accused and Blake Deck as having been the perpetrators. Now there, we would say that in taking into account the open-ended nature of the sentencing guidelines, when you look at other factors after looking at the degree of participation, that ought to reflect that these 2 persons won't be sentenced to the same sentence. When you look at it, the crime is the same, but there is room for the degree of participation of the persons. If I may give an example, if we were dealing with a crime, the most common, my lord, would be where a group of people would have committed an offense. Let's say it's, and then one of the persons would have be the one that has thrown the real blow. The courts tend to separate that at the sentence level. At the conviction level, it will be the same, but at the sentencing level, you would have to separate the 2 persons. That is my first submission in respect of section 9, paragraph K of the sentencing guidelines. We talk about the degree of participation. Then the second and last point, it's a point that comes out of the facts of this case. Perhaps my lord is looking
Yes. Yes, I'm just looking.
at the second one and last point which I'm making it because I want the state to respond. The court has to take into account the circumstances of the commission of the offense. Can we say that this was a very complicated fraud? I will pause and I want to answer that question. Would this be a complicated fraud where you enter into, various schemes that would be? It would be a very simple offense. The offense was committed by a misrepresentation relating to the tax status of a company, the company called Black Tech, so that its tax clearance certificates and the NASA certificates were found to have been fake or to have been fraudulent. My lord and lady assessors, I want to draw the attention of the court to what I would call contributory culpability of the victim. So that is the concept I want to introduce. It must be taken into account. We have seen the victim assessment report and the witness who spoke on behalf of the victim. The victim here would be the state. But the state was grossly negligent in the circumstances, completely negligent. They actually had a committee headed by a lawyer, which was to look at all these submissions. And my lord, in your exchange with my learned friend, Mr. Court, you did indicate that there are cases where you would say, someone says, okay, you found me out. I'm sorry. This offense could have been prevented at a very early stage. It would have been simply an attempt if those officials had done their work. What is it that stopped them from finding out that the documents were fake? There's no evidence presented before this court to say that it was going to be very difficult. Why would you have a whole machinery of a ministry that is a committee, I think it was called an evaluation committee, which evaluated nothing, because I think they should have easily discovered. So the accused persons, I'm not taking that away from them, but I'm wanting to submit that it was not a complicated fraud. And that must be taken into account, especially now when we look at the second accused, in the sense that the state contributed. So we would reduce under the victim if we take the state as a victim, and would say that the victim did contribute. That's the point I'm making. I don't want to be seen as if I'm saying that you should, we are not saying they didn't commit an offense. They committed an offense. But when I'm looking at the prejudice that this country suffered, which my little friend wants to go to town about, I think when he was cross-examining Mr. Mpofu, he wanted to create the impression of a high priest who would say, look at the kind of mistakes that you made. There are people that are suffering, widows, children. I mean, that's what they were saying. But it is not the accused only that are responsible for that. His own state officials, who are, I think that is why there was a procedure which was complicated and detailed. That procedure which said you flight a bid, you put requirements, you say that you must have, comply with this, then you don't check. But they then disqualified others. So I want to reduce the moral blameworthiness, if I may put it that way. The moral blameworthiness of, if the state had been cheated left, right, and center by sophisticated accused persons, which is my learned friend with some guy said, is very simple people. So we're not saying our clients ought to have done that, but there should be enough checks and balances in any system running a government where you would have your people. Let's say you wanted to cheat our way into this court, my lord. I think the registrars and others would have found that out. But let's say we try and everyone is sleeping. Then we are found out. When we are being punished, you cannot fail to take into account the fact that there was a lapse, the system was lapsed. So I would want to invite this court, in sentencing the accused persons, to make a statement also clear to the country, so that the public is aware that it is not because of these two people that we are where we are. Yes, they have contributed, but the state machinery is very much also culpable. It is only the degree of culpability which I may not be able to assess. But if I had my way, We should have found some crime of negligence. We should have found those witnesses that took, I think most of the time, my lord and lender was taken by these officials that ought themselves to have been answering for why they didn't, at a very early stage, find out. That is my submission. So we would pray that. So I think thank you for allowing the indulgence. I'm exchanging with my learned friend. We wanted to add then, in this case, with the second accused. When we read the judgment, there is reference to the fact that his company was paid 200 million. It would appear that that may be taken as a factor suggesting what the extent of the involvement was. And then when we listen to the Mr. Minduru, that witness, we were very generous with him. We didn't ask him much. You know, my lord, at the end of his submission, he then suddenly told us that he had left the department responsible for this. He also said that there was no government report on an assessment. He was relying on his own report that he had sent to the relevant bosses. That's what he said. In fact, the only thing he remembered was that he wrote something himself. He didn't tell the court that there is a government position clearly setting out the extent of the damage. That is not there. So it's speculative. All these things about how far the program that he referred to, I think he referred to Vision 2030, how far it had been undermined. And with the submission I've made, I would want that the public knows that if there's going to be any undermining of that, it would have to bring in the state officials, that next time they must be careful. So we think that with an appropriate sentence, it's possible that this court could say that our client may never participate in any future, for some time, programs that have to do with state procurement. That would be taken into account in addition to what has been said. Now I want to come to the difficult question, my lord, as to what would be the appropriate sentence for the second accused. We have seen that in this case, and that's our submission for my learned friend, Mr. Mukia, which is our submissions, that in our case, the mitigating circumstances far outweigh the aggravating circumstances. If it is going to be an imprisonment sentence, it must be a very short one. We say so on the basis that, particularly when we look at pages 51 to 53 of the judgment, I would very much urge the court to do so. It would appear that the conviction relates to where the court discusses the role of a director, and that he was more or less somewhat de facto or an otherwise director of Black Deck. That is the way it is coming out in a way. And that ordinarily, where your liability is coming because it's a company, a corporate entity, the company itself would be fined. Then where we face liability on the directors is because they would be possible that they can be punished and imprisoned. Because of the nature of the offense, an imprisonment term may be unavoidable, but it must be a short sentence. That's our submission. How short we would not be able to suggest the length of the. We would not go so far as to say that this is in the circumstance of the case, that it must be a fine only, in view of the public interest that has been generated by this case. But it must be way, way below anything that is close to. If there had been anything, we would suggest that the time that he has served in the remand would meet the justice of the case, which is actually now close to 2 years. Those would be our submissions, man.
Thank you. Thank you very much, Mr. How long do you think you need?
30 minutes. I don't know the student already, they have filed
Yes.
an aggravation.
Yes, I think now it's just rebuttal.
Yes.
Since you made your submissions in detail, it's just a question of rebutting the mitigation.
The state will abide by its submission in aggravation, filed of record.
Yes, thank you. Proceed, Mr.
Yes, my Lord, one of assessors, the state would like to remark that this was quite a very long trial, but upon its conclusion, if one were to comment on the offense committed by the two accused persons for which they have been convicted, the only two words that comes to one's lips is that what and bread would greet by the two. The program was in terms of the victim impact assessment report, the paragraph 3 was targeted first. Its target group was said to be that the first priority. The first priority groups of beneficiaries were rural vulnerable households as contained in the database with Ministry of Public Service and Social Welfare that included disabled person-headed households. Secondly, child or youth-headed households. Thirdly, elderly-headed households. And lastly, widow-headed households. And then lastly, chronically ill and orphan-headed households, and thereafter the rest of the other households. My Lord and Honorable Assessors, each household was meant to benefit a single goat out of this project. A goat which was on average worth about 40-50 United States dollars. This was going to be an asset in these households, which was meant to make an effort. These are the people who should rightly be referred to as being the victims of the crime. They were the beneficiaries. It is not the government of Zimbabwe which has lost. These are the 5 groups which are itemized in the 3rd paragraph. The program was quite noble. Over 600,000 goats were supposed to be delivered to all sorts of households, and 87 million United States dollars had been set aside for that purpose, and over 7.7 US dollars had been actually paid to the accused persons, who were supposed to deliver out of that money over 85,000 goats, which were supposed to be distributed to different families. And out of a possible 85,000 goats, only 4,000 goats were delivered. The first accused person tells this court that there was the improvement of a dam in his farm, the improvement of roads within his farm. there were salaries, there were all sorts of benefits that he got. Out of the 7.7 million United States dollars, only 330,000 United States dollars was applied to the purpose for which it was meant. Money was being changed into the black market, and it was never accounted for. Clearly, my Lord and honorable assessors, the blameworthiness of the accused persons is very high indeed, in that they stole from very poor people. I don't think they even imagined the type of people who stood to benefit out of the project. Now, in terms of Section 9 of the sentencing guidelines, the only factor that is to their benefit is that they are first offenders. That is all, out of from A to J. In terms of B, the offender, did not really admit to the charge, and they did not plead guilty. C, there was never evidence of genuine remorse or contrition, either during the course of the trial or during mitigation. And D, evidence of physical or mental impairment of the offender. They are not mentally or physically impaired. They are not they are not youthful offenders. And in terms of F, one cannot vouch that they are unlikely to re-offend, given the way they committed the offense for which they have been convicted. And G, the offenders are not elderly, nor are they female. And H, there was no H is not applicable. I is not applicable. And J, there was no evidence that that restitution or compensation was going to be done voluntarily.
Just a minute. Just bear with us. Okay, you can proceed.
Yes, and Jay, there was no evidence that they intended to voluntarily compensate, to restitute. And K, both have been convicted as the co-perpetrators, and hence there is no need for them to apportion any degree of participation in the commission of the offense. Then, what is of interest is the last one, the I, evidence that the offender spent inordinate time in pre-trial detention. My Lord, this trial was meant to commence on the 1st of October 2024. They raised 18 grounds of constitutional infringement of their rights. They made the application for at length for the accused of this court, even saying the continuation of the participation of the court would leave a nasty taste in one's mouth. All sorts of things that they said, all in the hope that they did not want the matter to be finalized. Unnecessary applications were made. Part of the bench was said to be too old and it was supposed to vacate. Section 6 of the High Court Act was raised in a very brutal way, and the bench was cannibalized. So, really, for one to say one had
make
been...
the bench very angry.
It's on record. I'm sure the bench is already angry.
Okay, proceed.
So, you know, the accused persons and even with their legal counsels, they were supposed to really they did not do a good job out of it. Their behavior in contributing to the delay from the 1st of October to today, the 3rd of December 2025. The delay was of their own making, and they cannot be made to benefit out of that. It was a trial which was meant to last a week, but it has lasted a year and a half. In view of the applications that were being made throughout the trial, baseless as they were, highly provocative as they were, time-consuming as they were.
Yes, proceed.
One implores this court that there was a very that the court should consider pre-trial incarceration. This offense had occurred. The accused person had been arrested on the 26th of June 2024, and by August they had already been indicted. They had been given a trial date. It was about 2-3 months. The trial was fast-tracked, and the trial did not move. And all the reasons for the failure in the quick conclusion of this trial, they are all contributed to the accused persons and their legal practitioners. They would boycott this court. At one time, you find one counsel, or all counsels might not turn up. So it is surprising that then they would stand up and say that there was a pre-trial delay in concluding the matter, and therefore it must be taken into consideration. This is one case where the pre-trial incarceration mustn't be taken into account. If there is any time that the time that must be taken into consideration is between the 26th of June and the 1st of October 2024. That is when that is only the period when they had not appeared before the Honorable Court. Now, when one then looks at Section 8 in terms of the aggravating circumstances, clearly in terms of Section 8B, there was clear evidence of prior planning and premeditation in order for that offense to be committed. In actual fact, the aggravating circumstances, they far outweigh the mitigatory factors. And when one goes to the table on page 950, 954, not 1954, but rather 953. My Lord, almost all the aggravating circumstances, factors, are in existence. The items, funds, or property involved were of a considerable value. The potential prejudice was 87 million United States dollars. And the actual prejudice was over 7.3 million United States dollars. That is, which is quite a big amount. Then the funds or items involved not recovered. Over 7.3 was not recovered. In particular, it is the amount which was not recovered is quite huge. And offense, the offender was the offense involved loss of public funds. The amount involved was from the consolidated revenue. There were public funds without doubt, and also as bidders of a government contract, the state implores this honorable court to find that they were in a position of trust in that they were dealing with government funds. They don't, in order for one to be in a position of trust, it doesn't necessarily mean that one has to be a public official. Here, the accused persons were involved in business with the government, and it involved the public funds. And therefore, they owed a duty of care in that these were public funds. And therefore, the state implores that they be found to have been in a position of trust. And therefore, it is the state's contention, this is a humble submission, my Lord and Honorable Assessors, that in view of the existence of 4 out of 5 aggravating factors, the presumptive penalty ought to be 20 years imprisonment. This case was not committed in mitigatory circumstances. The mitigatory circumstances there are two of them which are given. Potential or actual prejudice was low or insignificant, which is not the case at all. The actual prejudice is over 7.3 million United States dollars, and the potential prejudice was over 87 million United States dollars. Then the second consideration is that in order for one to benefit from sentence of 6 months is that voluntarily compensated the victim in full. The accused persons did not want to hear about the issue of compensation at all, despite the fact that the state had at one point insinuated that it intended to proceed by way of section 50, subsection 1, as read with section 39, subsection 4 of the Money Laundering Process of Crime Act in trying to recover the lost money. They did not get a hint out of that, that if they really wanted, they could have offered not what they could in order to mitigate the loss by the state. This is money which was meant for very poor people, but they did not do so. Now, the issue which was so scary to my learned colleagues is to talk about the presumptive sentence of 20 years.
Which print?
My learned colleagues, both of them.
I think the second accused person considered that the presumptive penalty we should start from 20 years. But then they said, well, because of the strong mitigating factor, it should be way, way below the 20 years. Just a second. Is that what you?
Yes, that is correct.
They are meeting a step from there, but because of what they say was his minimal involvement. So you are dealing with Mr. Koto only.
Yes. Yes. Let me deal with both. This court has spoken in recent times about such offences. It has dealt with the Mpamaonde cases, the Luca Lavina and others which are quoted in aggravation. And not only that, there is a similar case which was dealt with by this honorable court. Tinashe Banda.
By the way, what was the sentence in the Mpamaonde case?
Mpamaonde, in one case where they were involved in both of them, the part A and part B. One, there was a fraud pertaining to the building of bridge, and the amount which was involved was 18,880. They were given a sentence of 18 years. And the second one, which involved 17,990, they were given a sentence of also 18 years. They were separate cases. But there is another one for Tinashe Youth Band, which is High Court 138 of 25 by this court, where Tinashe Youth Band had forged a certificate that he had been exempted by Zimbra from paying duty, and he then imported fuel with where duty in the sum of 2.1 million was supposed to be paid, but he had not paid because he had used a fraudulent document. He was then sentenced to 20 years, of which 5 years was suspended, and he was left with 15 years effective. My Lord.
Sorry, I'm just trying to refresh my memory. Do we have the citation there?
Yes.
Ah, okay. Thank you. All right, thank you.
Yes, my lord, the state was taken aback by Mr. Koto when he was quoting sentences which were passed in 1992, 1984. Very old cases. It's no longer business as usual with the coming of the sentencing guidelines. The sentence guidelines is very clear. And in the present case, the starting point for this court is 20 years. That is where it has to start. And similar cases, although which were not as serious as the present one, are the Mpamaonde case, the Tinashe Use Banda case. Well, Tinashe Use Banda, it involved the amount of potential prejudice of 2.1, but the one before this court is the actual prejudice of 7.3 million United States dollars and the potential of 87 million United States dollars. This honorable court has already spoken, and it should continue to speak with one voice on this matter, on the commission of similar matters. It will be a discord for if this honorable court were to be heard giving a sentence which is less than the one which was given in the Mpamaonde case, given the values. It will be a discord by this honorable court if this honorable court, same court, were to give a sentence less than what Tinashe Use Band was given by the same court. In the Tinashe Use Band, the victim was the government of Zimbabwe directly. In that those are the ones, that was the one which was supposed to receive the duty from the imported fuel. And in the Mpamaonde cases, yes, it was a service which had not been provided. But in the present case, which is much more serious and where the victims are the poorest of the poor, who stood to lose out, they cannot therefore get any sentence less than what the other quoted cases got. In recent years, there was never any case which was similar to the one before this honorable court. Before this honorable court, maybe one could think of the Samson Mashata Pawen. I'm quite sure Mr. Maduk is aware of it. I think if he were prosecuting today, that would be the first case that would come to his mind. That was one case shocked the
citation?
It was in 1984-85. I'm sure Mr. Maduk would know. So that was one such a serious matter. And therefore, what has been suggested by my lady colleagues, the state, it feels scared even to repeat such sentence, with Mr. Koto maybe suggesting a non-custodial or sentence, as if he was saying that at gunpoint. It can't be said to be even a slap on the wrist, a non-custodial sentence. At least Mr. Maduku was saying of a sentence that he could not mention, but he was saying it should be a custodial sentence. But he didn't want to commit himself. He had realized the seriousness of the matter. But in the presence of his clients, he could not come out to say what sentence he could suggest. But I'm sure outside you, you will agree with the state. The state has suggested a sentence, my Lord and Honorable Assessors.
What is the sentence?
It's written it's on page.
Yes, I just want you to say it.
Now, the serious, the offense,
I think it's towards the end.
Towards the end,
I've
yes.
just been looking at it. It's at paragraph 20.
yes. If the state is,
Wherefore, actually, it's the concluding paragraph.
so if the court has already seen it, I think the state won't have to verbalize it.
No, I want you to motivate.
But that is the proper sentence.
Well, you recommend imprisonment for 35 years. Is that not the maximum penalty?
It is, but this is one such a case where one can think seriously about the maximum. But it has drastically reduced it.
By suspending portions of it.
Yes, drastically. And the end result remains very reasonable.
Like you said, when I'm perhaps Mr. Madu's generation perhaps older than him, so I also remember the Samson Pashata case. We thought there would never be a more serious case. Now here we are.
In our lifetime, we have seen
going
it.
by the judgment. So can we give the maximum penalty or always reserve it for the future?
But the effective sentence is very low. Very, very low. Compared to what people like Pardon Ziwa got. He stole $10,000 and he was given about 10 years, one suspended for fraud of that nature, which was just money for lunch compared to the one before this honorable court. The Mpamound and others, it was 18,000 and 17,000, then they get 18 years. The case of Chimombe, where Mr. Madugu argued his lungs out at the Supreme Court, but the sentence was found to be proper, where he got 8 years, one suspended, who was jointly charged with Pardon Zero. But those were small cases compared to the one before this court, and it did not involve very vulnerable people. If this court were to give anything less than the presumptive sentence, any sentence below the presumptive sentence, it will give confusion to lower courts. There's been consistent trajectory by this court to draw a line on the sand. But if then this court then said one where it involves actual operation 7.3 gets less than the presumptive, then it means people who are in custody who are stealing $1,000, 7,000, they are not supposed to be there. They have to be released without any appeal, because the sentence won't be in line with what is before this honorable court. So my Lord and honorable assessors, I'm sure the sentence that has been suggested by the state as read by the honorable court is the most appropriate sentence under circumstances. The sentence that must be, that this court has to deliver must send a message that if one is given a contract, there must be a culture of delivering. One must be satisfied with the markup from the profit. This is the message that must be sent. So it's not a matter of every Tom, Jack, and Jill opening a company, then you start looking for tenders. There must be a message that if you want to be involved with tenders, there are consequences if you don't deliver. Yes. So that is the message that the state implores this honorable court to send. Yes. I'm sure the sentence that has been suggested by the state might be lenient before this court. The state at one point in the case of state versus it was state versus pardons you. It actually suggested the sentence. When it suggested 8 years, the court in its judgment totally said that sentence is too lenient. It wasn't going to listen to such sentence. And the court implores this honorable court to take the same position. That is all that the state wishes to say.
Yes, Mr. Maduku has said something about co-perpetrators. What do you understand co-perpetrators to be?
No, the law is very clear. I'm quite sure Mr. Maduku is clear that the co-perpetrators are liable to be punished as the perpetrators.
Yes.
Yes. So there is no need.
Okay, no, I just wanted you to respond to that because he said he's charged as a co-perpetrator of the actual perpetrator.
In terms of the law, it does not make any legal difference.
Yes, thank you very much. Thank you very much. Yes, Mr. Koto, there's just some clarification which I needed, which I could not seek before hearing the state, I didn't want to preempt submissions. But since sentencing is an inquiry, I want, courts take contrition very seriously. You understand? The prosecutor has even hammered on it. He has said, look, this trial was delayed, it was not a very peaceful trial, and so on and so on. You seemed to concede in your submissions that there was no valid tax certificate or compliance certificate in the first place, which is the reason why it was, I don't know what the word you used, I don't remember now. Just wait. Fake qualifications, that's the word you used. And they accused, your client also sort of apologized. When and you recall, maybe you had not joined the trial, I'm not sure. But you recall that the official from the ministry, from Zimra, said he did not only examine those certificates, he went into the system to see whether Black Tech was tax compliant, and he said it wasn't. That was not really disputed in cross-examination. you know, the trial progressed on that understanding. You understand? And the court even, let me say the judge, asked, you know, say to the accused person, you had this opportunity when you brought this other information here to kind of present some form of evidence that there was an effort to comply. Now suddenly you said he is now admitting, you are now admitting that just because the court found that is that based on the record, or it was just a submission which you made without applying your mind?
What I was saying is that during the trial, during the process of the trial, my client has always insisted that I was in the field. I did not know what was happening in the offices. So now, for him to insist after conviction appears to be critiquing the judgment. So we are.
Yeah, but I'm saying,
yes,
because when you say you are just admitting because he was convicted, you are saying, we know that that should be the position. You
yes,
could hear that from the submissions of your colleagues there.
Yes.
That's the procedure in court.
Yes.
When a conviction is ensued, you abide by it for the time being.
Yes.
If you are unhappy, you know what to do.
Yes, exactly.
And you could hear that they were basing their submissions on what is on record.
Yes.
You understand? So I'm saying, I thought that your submission was genuine contrition based on the acceptance that the witness testified that effect and they were not controverted. And that up to the end of the trial, there was no evidence to the contrary. And even in sentence, as we proceed, there's no evidence to the contrary. So do you want us to accept it as genuine contrition or I'm not sure now, I'm a bit confused.
Yes, my lord. This was to be accepted as genuine contrition because at the witness stand, the accused emphasized that
he should have checked. He said he would have done better.
Yes, he should have
which
done
means that he concedes that there was no way they would have been genuine. If he had found it, he said he would have reported something like that.
Yes.
Which I thought was that is what you were riding on.
Yes.
Now you seem to then say, no, it's just because we have been convicted.
No, maybe I did not come clearly on this one. Yes.
And then, secondly, who prepared that document which you have produced in mitigation?
He got from the company's accountant.
Is the author? Does the author appear on it?
What I know is that
Because it's just a one-page document.
yes, but what I know is that they were working together with the accused person on the figures with him.
Yeah, but does it show who authored it?
No, it doesn't. It doesn't say.
So does it help?
Yeah, in the sense, my lord, that at this stage, even a hearsay can be adduced, and my colleague did not object. So on the basis that they...
Well, the fact that the state did not object it does not mean that
yes,
we can't, we don't take precautions.
yes, my lord.
It doesn't have, why, you know, it doesn't tell us who prepared it and when
Yeah, but
and from what.
yes, my lord.
How much weight? It's about weight.
Yes, it's about
Yes,
weight.
it's about weight. Well, on where, who prepared it, from where, in what capacity, from what source documents? Does it say?
My lord, when the accused was giving evidence, he was talking of something that he experienced being on the ground. That's what he said when he gave
No, I'm
the
just
evidence.
saying, we don't know. The accused person has not even told us who prepared this document. It is here by, the fact that a document has been produced does not mean that it has any weight at all. We just want to know how much weight we can place on it.
Yes, as I am saying.
Other than it being on a letterhead. It is not dated. We don't know who prepared it. And normally, you know, in court, very experienced as you are, when you produce a document, somebody must vouch for it. Somebody must say, I prepared it from this and that information, which is kept by me or something like that. That's the tradition.
It's the unfortunate
You didn't
thing-
think about it.
No, the unfortunate thing is that when he took the stand, everyone was just concerned of having it, trying to shorten the process. That's why we even agreed that we was not going to go item by item. We omitted
No,
by
that's
that.
not the
Otherwise,
issue.
you would have been led on
That's
that
not
aspect.
the issue. What weight can a court place on a document which does not tell us the who prepared it and from what source documents? How much weight can be placed on it? It's before us, yes, but what weight can we place on it?
Well, given that it is a company document, I believe that...
Where does it say that?
It's on company letter.
So?
And the witness did indicate that it was prepared.
You mean company documents can be prepared by anybody? The precedents are there even in the Criminal Procedure and Evidence Act. Somebody who produces must say these are documents, this information is something which is within my control. I keep it. Or if he's not the maker, say I have access to the files and I've done that and this is what I see. So how useful is this document?
My Lord, the witness said that he asked the company to provide information.
That's
what
the
he
best
said.
you can do.
Yes.
Okay, thank you.
Yes.
Is there anything you want to say further to the questions that I put to you? I'm not like saying mitigate again.
No.
I just did not want to pose these questions to you as if I want to give the state some ideas.
I'm just responding to points of law to what you have said.
Oh, okay.
Yes,
All right.
yes.
Thank you.
My Lord, I would like to distinguish the case of Tinashe Yusland from the current case.
Okay. What is
The case of Tinashe Yusland.
What is the citation?
Well, I did not get it, but it is cited by my colleague in his...
I've been trying to go through, but anyway, I'll get it.
Well, it's I got Harare 138 of 25.
Thank you very much.
Yes. My Lord, that case is distinguishable on the basis that that was a pure case of smuggling. Each and every transaction was a commission of an offense. There was no possibility of delivery in that case. But in this case, we are saying the accused were convicted of using fraudulent documents. There was a possibility of proper delivery. So in the Tinashe Yuswanda case, the person had already made up a mind that how do I siphon $1 million from the state? I do so by faking documents so that I import fuel duty-free and I get that $1 million. So it's quite distinct from the case before. Furthermore, and that also works in respect of the other cases cited by my colleague. In all those other cases, there was no guarantee provided. In this case, my Lord, there was a guarantee which was worth double the amount that was advanced. So what we did not hear my colleague to be saying is why the state did not call upon the guarantee.
So do you think that the bank would have given this guarantee if it knew that there were forged documents that were used?
I can only speculate, my Lord, and I don't think it will be proper. Because what I'm saying...
No,
Lord,
why? That's a legal issue. That's a legal issue.
Well, it would have traded with care.
Yeah, the bank was guaranteeing who?
Was guaranteeing Blackdeck.
What? Blackdeck what?
To...
Blackdeck who? We have synonyms here.
Well,
which Blackdeck?
In fact, no, not Blackdeck. It was guaranteeing the ministry to say if you give them the amount, we have got 3 billion.
Give who?
Blackdeck Private Limited. If you,
in other words, it was a document required before a contract is entered
yes,
into, isn't it?
yes.
So who entered into a contract with the government?
It's Blackjack Private Limited in that other name, Livestock and Poultry.
You still insist that Blackjack Livestock was another name?
Well, it's Blackjack Livestock and Poultry, my lord.
Yes.
Yes.
Does that name appear on the guarantee?
On the guarantee. Well, it would not appear on the guarantee, but all the same.
So why would a guarantee for Blackjack Private Limited be a guarantee for Blackjack Livestock and Poultry?
My lord, I say so because there has not been allegation that when the state tried to call upon the guarantee, the bank said, no, we did not guarantee this particular entity, but that particular entity.
We are talking about potential.
Yes.
Potential prejudice.
Yes.
The state now presents a contract between it and Blackjack Livestock and Poultry,
Yeah.
in order to, call for this guarantee. Was there not likely to be a complication there in the eyes of the law?
My lord, as I said, that would be complication because there has never been any attempt to reduce the loss by calling upon that guarantee. There was never an attempt, and that can only be interpreted to mean that the ministry was aware that it was to blame for what had happened.
Okay, thank you.
Yes. So in all those other cases, the other party to the contract was not, there was no blame whatsoever that could be attributed to them. Okay. And so that is submitted earlier on, my lord, should be highly mitigatory. Then lastly, my lord, that the accused person stole from very poor people, as submitted by my colleague, that should not sway the court into imposing a harsh sentence against the accused person, because these poor people, as my colleague would want to put it, could only benefit once payment had been made by the ministry as the contract.
Where are you getting that slip from? Where are you getting that slip from?
Well, it's just what I believe it is my client.
What is the procedure when you want to take instructions?
So I had no intention to take instructions, my lord. I just
What are you doing?
Well, I thought maybe it could be a case, a similar case like when we adjourned, maybe there was a problem. So since I am on my feet, perhaps I wanted.
Yeah, but what is the procedure?
If
If you realize that there could be a problem,
yes,
and your client needs your attention,
yes,
what is the procedure?
I could have asked leave for the court.
Why did you not do that?
Well, I was just taken by surprise. I'm sorry about that. So, what I'm submitting was that benefit, because there was no direct contract between Blackjack and these people, it cannot be visited upon them. In the contract, there was a provision that in the event of failure or defective performance, the ministry was going to perform, then levy whatever it had suffered against the contractor. Again, we have not been told as to why that procedure was not told. The only possible interpretation that can be given to the scenario as it happened, as it unfolded to the end, was that the state later on made up its mind and decided to discontinue this program, given that the first batch of awards was only delivered way after cancellation. So it cannot be visited upon the accused person that poor people failed to receive the goods that they were intended to benefit from. I think unless
Any reply on the law?
Yes, just a briefly reply. The first one, we reply in respect of the co-perpetrator. We have submitted on behalf of the second accused that he is convicted as a co-perpetrator and he is entitled to the benefit of Section 9, Paragraph K of the sentencing guidelines, that the court can take into account his participation, and our submission that the participation is minor. So we want to respond to the point that Mr. Mabaude has made, which is that it doesn't matter as long as you are co-perpetrators. It is correct that for purposes of conviction, my Lord and Lady Assessors, they would be treated as the same for to be convicted of the offense. That is where it ends. And if the court looks at 196A, it's very clear it has an actual perpetrator. But there are certain situations where perhaps the court could go to the section.
You're saying in terms of section?
196A of the criminal law codification format. I'm just taking it as reproduced in the judgment at page 40.
Yes.
And the point we are making there,
Maybe we should start from reading it.
yes, I would read it and indicate. Yes. It says that if two or more persons are accused of committing a crime in association with each other, and the state adduces evidence to show that each of them had the requisite mens rea to commit the crime, whether by virtue of having the intention to commit it or the knowledge that it would be committed, or the realization of a risk or possibility that a crime of the kind in question will be committed, then they may be convicted as co-perpetrators, in which event the contact of the actual perpetrator, so the word actual perpetrator is put, in which event the conduct of the actual perpetrator, then in brackets, even if none of them is identified as the actual perpetrator, shall be deemed also to be the conduct of every co-perpetrator, whether or not the conduct of the co-perpetrator contributed directly in a way to the commission of the crime by the actual perpetrator. I want to just start there. What that tells us is that there can be, and there are situations where one of the persons in that group would be the actual perpetrator. Then the conduct of that actual perpetrator is visited on the rest of the other group. And for liability purposes, they are equally liable, so they are equally convicted of the same offense. No problem. Yet, so you cannot ignore the fact that there is an actual perpetrator. But where the court finds that there is an actual perpetrator and the others are in it for conviction purposes by virtue of the conduct of the actual perpetrator, our submission is that when we come now to sentencing, when it comes to sentencing, you ought to look at the conduct of each person for sentencing purposes. For conviction purposes, they are visited with the same. That's what, so that distinction is made. And that is why Section 9, subsection K, paragraph K of the sentencing guidelines then say that you look at the degree of participation. Is it minor, is it major? This is of a person who has been convicted of the offense. And I don't think you can have a minor role in the commission of the offense if you are the only person. That's the point we are making. The minor role presupposes group participation. And certainly, it would be logical, my Lord and Lady Assistants, to say that for sentencing, we don't take into account. The law has already done far too much when it visits you with the same conduct of your colleagues. So you are convicted, it's clear. But when we get to the process of sentencing, so that is our clarification on the law. It's possible that
it's a co-perpetrator as opposed to an actual perpetrator.
It's not an actual.
So which section deals with actual perpetrators? In terms of their liability. I'm saying, you are saying this deals only with those people who associate themselves with actual perpetrators. And which section deals with actual perpetrators?
My Lord, perhaps the court has not, I'm saying that section deals with both actual and co-perpetrators,
yes,
for conviction purposes. They are the same.
Okay.
But for sentencing purposes.
I will hazard what I thought that section, and you can disabuse me of any misconception. I'm almost certain that this is a codification of the what was the common purpose doctrine, where people act in common purpose and with the same means, intention to commit the crime, they would obviously play different roles in the commission of the crime. One might provide the means, the other might, one might provide, let's take meta scenario. One might provide the knife and say, knife him, kill him. The other one might take the knife and stab. These are people acting with a common purpose. They are that is what I thought co-perpetrators means. In other words, one might be responsible for the actual role in terms of providing the knife, and another might be responsible for the actual role in terms of stabbing. So the one who provides the knife did not actually stab. The one who stabbed did not actually provide the means. So they are contributing towards a common goal. So you don't now need to say, well, I just provided the knife, I did not stab. You are also guilty of murder. It's what usually happens in public violence cases. You are involved in public violence, and then you are not everywhere. Cars are being stoned. You are liable for the car stabbed. If you are A, for the car stoned by B. That's, in layman's language, that's my understanding. So, and I got a bit worried when you said it means something else. So I want you to disabuse me of a misconception if it is.
My Lord, you, with all due respect, you'll be correct there. It might not be word for word that the attempt of the legislature is to codify common purpose.
Yes.
Actually, we do have the case of Mazokera versus...
Yes, I remember that.
Yes, so we referred to the judgment of justice.
We read that, yes.
So it's a codification. So as far as conviction is concerned, it doesn't matter what role you have played. You are guilty of murder.
Yes.
But when we then go to sentence you for the crime, we must take into account
Section 9.
Exactly.
Oh, that's what you are saying.
That's the argument we are making.
Okay, that's the
In
argument.
fact, my Lord, because you have then gone that far looking at the common, even under the common law, you separate the two worlds. The conviction, for conviction, the law is clear. We don't say you have all the common purpose of committing the offense, so you are guilty, regardless of the extent of your role. A small role, a big role, you are all guilty.
Yes.
Then when we come to sentence, we will have to separate those roles.
Okay.
Yeah,
no, I understand that now. I thought you meant that he played a lesser role in the sense that he simply associated himself with a crime that was being committed by another. But I thought co-perpetrator just means that it's being committed by them, not that he's associating himself with a crime committed by another. But of course, different roles may be played. I accept that.
Correct.
Yeah, different roles may be played, but I'd misunderstood you to be saying he's associating himself with a crime committed by another.
No. He committed the crime.
Okay.
And he was found guilty of the crime. Yes. And we accept that he committed the crime.
Yes.
And then when it comes to sentencing him, you are required to take into account the role. In other words, for sentencing purposes, our submission is that the law requires the court to take into account the different roles.
Yes, I could see Mr. Mugia uncomfortable when you said he committed the offense. I understand this is in the context of mitigation. It's very clear that you are just...
No, my Lord, I wanted to tell him some other point that
I see. I'm quite mindful of that. That is not really a plea of guilty in mitigation.
Thank you.
In fact, we our team were clear on that.
On that.
And when he presented, he was also very clear.
Yes.
But we really want to be understood on this.
Yes. No, I understand you. What the point is.
My little friend had misunderstood it, and he had misled the court with respect on the law, because the law is clear. Our client is guilty in the same way, clear, but he is entitled to be treated differently when it comes to the role that he played. And this is where we have made the point, which is Section 9, subsection K. So that is our first clarification of the law. Then the second clarification on the law relates to the position of the pre-incarceration period. Our learned friend has gone to town on the various applications that we made, what he claims to be the delays that were. He is clearly, with respect, wrong on the law. the accused persons were undertaking the rights that they have in terms of the law. Every application was founded on a law. There is not a simple application which was said to be improperly before the court. Every application was found to be properly before the court, but was dismissed. And we take the one where he was very unhappy with that attempt we made to apply and make reference to the Constitutional Court. Took us some time. This court then dismisses on the merits that it was frivolous and vexatious, which is the test that is applied by the Constitution. But the making of an application which is then found to be frivolous and vexatious would not mean that you are allowed by law to do that. So our response is that the pre-trial incarceration period ought to be taken into account, regardless of the reasons. Because as a matter of fact, they have been in custody for 18 months. That doesn't change that because they were responsible for it. The legislation is clear. That's our submission in respect of that second one. Then the third response relates to the element of prejudice. The state fought this case on the basis of actual prejudice. So if the potential of prejudice is not relevant. The charge itself was on the basis of the actual prejudice, which was said to be 7.7 million. And the state fixed itself. It can't then say in the same, after the same, this says no, there was a potential of prejudice of 87 million or whatever. That is totally out. The court has to take into account the actual prejudice that was alleged. Perhaps, my Lord and learned assessors, we think that the court has to take judicial notice of what was coming out from the witnesses, especially the first accused. He did indicate, despite this going into what was then called the parallel market, but 7.7 million was based on the parallel market, the state's official exchange rate. But it's obvious that the amount involved is far less than 7.7 million in US dollar terms. We thought the court might take judicial notice of that. It was not, because it's not correct that was 7.7 million in actual fact. At the sentencing level, that is.
How much was it?
My Lord and learned assessors, we don't know the amount. But I think we should take judicial notice of the fact that it was not 7.7 million in actual fact. Once you say that they went, which is what the case of the state is, that you went to the parallel market. And parallel market rates keep changing. And the state in its calculation of the 7.7 million as prejudice was not based on the parallel market.
I totally understand where you're coming from when you say it may not be quite that, it may not be there because of the volatility of the rates. But there are two issues arising from that. Were the parties dealing with this money on the basis of the parallel market?
Thank you, my Lord. They were dealing with it on the basis of the official.
Yeah, well, but still, yeah, I understand we can still consider the volatility. But the other question too is, do you not believe that it was going to be very useful to them, at the very least in mitigation, if they'd volunteered the rates they were using and the amount that was raised? Because it was such an issue raised throughout the trial, up to the end of the trial. And even in mitigation, there's been no offer. In fact, what we have is the first accused person now saying, no, there was no question of, no. So what figure does the court now use? Because the official rate might have been unrealistic on the black market. Fair enough. But what do the accused persons want the court to work with?
Thank you, my Lord. Perhaps I need to refer you to the case of S. versus Harrington.
Yes. 1988,
Volume 2, Zimbabwe Law Report 344.
1988.
1988
2
ZLR 344.
304.
344.
Yes.
Then you could look at page 360A. The point I want to make there is that yes, there has been an imperfection in terms of the way we have prosecuted that point that is coming out. And we accept that it would have been better for the accused persons if we had somewhat taken the court into our confidence and we had actually placed these various things. But sentencing my Lord and Lady Assessors, it's a matter of discretion. Once the court accepts and knows as a matter of judicial notice that these rates are volatile and that these rates were changing, then in the proper exercise of its discretion, the court ought to take into account, in the absence of information. I'm here addressing you, my Lord, with respect on the issue of saying, what do you work with? You have to work with your discretion. It's sentencing. We have not provided you with sufficient information, but you cannot close your eyes to what you know. We know these things, and we would plead with you that you take that into account. That's the point we're making. And that Harrington case says that you take into account the crime and the offender. These persons were in custody, and I think the degree of flexibility of their movement would have been very different, even with our assistance.
What about the fact that the standard bidding document stated that the contractors needed to be ethical, and we know that anything contrary to the law is unethical, and that they were in fact fined for doing so. Would the court still be entitled to then give them that benefit?
Indeed, my Lord and Lady Assessor. That's why I referred you to that case. I think when you are sentencing, my Lord, you can forgive me if I...
No. The reason why I engage you is so that we properly we help each other to make the correct decision.
Yes, I think you should take that into account. It's this so-called discretion. It's a very broad term. The court ought to bend backwards. It's a discretion. If I were to have my way where I said you can forgive me, you are like a parent. Yeah. Although you might be younger, but no, they are all younger than the, most members of the court. But you are playing a very delicate role when the sentence, that's what our law says, it's a discretion. You take into account the imperfections of the prosecution of the matter, even the mistakes that we have made as counsel. It's not a very strict fact-based framework where we are. We are in the world of discretion. And we want to implore that the court takes that into account and get this issue clearly. I think the court has heard me there. And then there's the last point which I am feeling very strongly, my Lord and Learned Assessors. The state has behaved as though sentencing is a mathematical exercise. A mathematical exercise when you say, okay, someone with 10,000 was given 8 years. You might give them 300 years if we go by the way he has argued this matter. And say, okay, 10,000 is in jail for 10. So what is that? It's completely not part of our law. Our law says take into account the crime, the seriousness of the offense, take into account the offender, all the facts that we have placed before the court ought to be taken into account. They might end up with a far less sentence than that if we get to look at what is happening. So I wanted that to be clear. So sentencing is not a mathematical exercise. It's only that Mr. Mabaud may not be able to calculate anything. If he had, he would have given you, I'm not sure what figures he would have come up with. Remember, he didn't want to read his 35 years. And my Lord, this is, he himself says that he can't. He's wrong on the law because the presumptive sentence applies when all those aggravating circumstances are there. The 35 years he had is the statutory penalty. I think that if the sentence guidelines are looked at, they have the statutory penalty. And the purpose of the guideline is to depart. It's more like a way in which they are amending the act. They say, okay, this is the statutory penalty, which is in the act. But we don't want courts to apply it. Regardless of it, apply it to it. So 20 years is what would apply with all the aggravating features. If he wants you to go to 35, he has to give reasons. In other words, give you aggravating features which are not in the sentencing guidelines. Now, he was marking and saying 4 out of 5, then 2 out, that's what he was doing. Now, if he says it's 4 out of 5, then it's actually less than 20. That's the way the sentencing guidelines are. If we is all 100%, then it is 20. That's how they operate. If he wants you to go beyond 20, he has to give you those. And I thought we should say that point, that it's not a mathematical exercise. It will completely be ridiculous if that were to be the case, etc. Then I wanted to express caution on the recent cases that have been cited. I would say that the court ought not to look at the cases in 2025. The Mpama on the one, my learned friend has to open up with the court. We are in the Supreme Court with those cases.
No, so you're always fighting.
Yeah, we are always. In fact, he has not been to this constitutional court in his life, so he's now going to start in the case I'm going with him. So this is, yeah, I mean, we have been fighting, so he will soon be in the constitutional court. But the issue I wanted to place before the court, my lord, is that these cases, the court, I think we should not, with all due respect, apply them. In the Mpama cases, one of the reasons why I was with him, and in the last case before Justice Chitakunya, he can confirm that one of the easy reasons why the Justice Chitakunya said, look, whatever you people want to argue, but we will give them leave to appeal. They had been denied leave to appeal by this court. They got leave to appeal very easily on the basis that the sentence, it struck a single judge of the Supreme Court as completely, I think, outrageous. So we would not want to recommend that this court looks at these cases, especially where cases are still subject to appeal. And if the fact is made, the court is made aware of the fact that this is a case under appeal. I'm not aware of the Tinashe Hills-Vander case, but I'm sure it will also be appealable. It is important that the court, I think, treads carefully on those points. I think those are my points as a matter of law. I hope the court has also noted that he says that public office, you can say that they are in an office of trust, but the reason for that provision is for a person who steals funds that they are keeping in trust. Even if they have some responsibility, but you can't make it visit these ones. Those would be our clarifications. We really implore the court to take into account the fact that whatever the case, we should still play and take into account that we should not crash. If I may read and then sit down, my lord, and later says, it says that. Yeah, thanks. I want to be, my learned friend reminds me that Ms. Mabaude has avoided totally the issue of contributory culpability. He has avoided it, which is it's a concession in failing to address a point which we have so prominently put across. And
contributory culpability with regards to, you're saying it reduces their moral blameworthiness.
Indeed.
Is that how contributory culpability works? Huh? I thought contributory culpability refers to in different situations, maybe it doesn't refer to vulnerability. I think it means contribution in the maybe in driving cases where you can't really say he was 100% is there what called
yes.
causa?
It's contributory negligence
responsible for some, so the accident occurred because perhaps he was negligent, but you can also see some negligence on the part of their, so you can't punish them 100%.
Yes.
In that crime, that accident, because there is contribution on the other side towards the whole scenario.
Yes.
And you think that reasoning applies to this case?
Yes, in fact, that's the point we are making. Actually, we think it is more applicable here. In civil law, my lord and land assessors, contributory negligence will not take away your negligence.
Yes,
it will reduce your liability, your contribution, to say, all right, how much damages do you pay? You pay less because the other. So we reduce the damages. This is the same thing. We reduce their contribution to the prejudice. We are actually looking at the point that has been made by the state, that you have affected all these widowed persons, child-headed families. We appreciate the notion of the presidential gold scheme, what was meant to achieve. But my point is that the more I think about it, my lord, and I must confess, the more I think that those state officials who couldn't easily pick a fake document are the ones that are responsible for undermining that program. And we would want this court to take into account so that we can't go to town and say that these two people wrecked. I think the way it was put by Mr. Mindur was that we didn't want to...
Was the misrepresentation, let's restrict ourselves to the tax certificates, clumsy? So clumsy that any person would have picked it up.
Indeed, my lord. In fact, when you listen to the witness, these things were only picked up, I'm sure, later by the officials from ZAC. But if you look at the structure of that ministry, with the permanent secretary, if you look at the machinery that is put in place to deal with tenders, why would we say as a state, we advertise for any citizen, bring in, these are the requirements, and then you don't check? If you are the state, there must be a machinery for you to say, is this document real? If it is from Zimra, why would a government department not be able to go next door to Zimra and say, in fact, they must have Zimra officials on their committee? So it was clumsy. It was such that...
maybe they were clumsy.
Yes, that's what I'm saying. They were simple. We don't want to get back. It is simple. You simply submit a document. We have seen, I've been to the magistrates court, my lord and learned assessors, where a lawyer just appears, they find they can't identify whether you look like a lawyer or you're not even properly dressed. They normally ask you to even submit a practice certificate. You can't just stand there and say, I'm so-and-so representing. Say, okay, we haven't met. Can we have your practice certificate? It's an inherent mechanism of checking. And my submission, my lord and learned assessors, is that the state has not been able to account for that huge machinery put in place to examine tenders. They should have identified that. And that would not excuse the accused persons. But I think in future, obviously with this case, I know that in future, I'm sure there will be rigorous checking.
I actually feel vindicated by you. You are submitting for me against Mr. Koto. He wants me to accept a document which is not, doesn't tell us who the author is.
Yes, but I think that is not, you still be in your right. That document would, we know that at this stage it's a real your discretion. So it shouldn't affect much.
And it's just a joke.
Yeah,
that's saying.
But those are our points.
We have a gatekeeping function. I'm sure that's what you're talking about.
Yes.
A gatekeeping function which must be exercised diligently.
Yes. I would say that because we've been lucky, and our clients may have to benefit from the fact that the whole trial was public, so the public has been following. You might find that they are also hearing where the blame must lie. They are to be blamed. But I think that if we were to do a referendum, I think the majority of the people would find the state officials more liable in their failure to... I would want... He has been checking what comments on social media. I think that the average Zimbabwean, the average, that right-thinking member would blame state officials. We should not have been here. Our clients ought to have been nipped in the bud right at the time that they were submitting the bud, at least for this black tag. I'm sure that's our submission.
Thank you very much.
Thank you.
That we had considered Friday, sorry, I had suggested Friday, but unfortunately one of the members has a prior commitment, and the suggestion is that perhaps we could come back to court on Monday.
The state will be in attendance, yes.
Mr. Koto?
Yes, I will be available.
Mr. Madu?
We would be available.
What's the date on Monday, Registrar?
8 December.
Stand up accused persons. We have had submissions regarding what we have to take into account in sentencing you. It has taken 1.5 days. We need to consider those submissions, consider them carefully, look at the cases that have been cited and consider the implications of those cases. So you will be sentenced on Monday, the 8th of December. At 11, are you available?
Yes, 11 will be
11. So come back on that day. If the lawyers are committed,
We will be there.
yes, thank you very much. I think we come to the end of business, the business of the day. Any other business? Yeah, John?
Future